Good morning, everyone. Can you just please put both thing you on mute? So where's the... Okay, there's no feedback now. Good morning, everyone. Welcome to the Education Committee meeting, bright and early on a Friday morning. Today, we are dealing with the consideration of the Western Cape negotiating mandate on the Basic Education Laws Amendment Bill, B2B 2022, as sent to us by the NCOP and having concluded our respective public hearings. Members, I'm going to go through the procedure in a little bit. I just quickly want to ensure that we all just introduce ourselves, and then I will take you through the procedure for our negotiating mandate today. My name is Deirdre Bartman, Chair of the committee meeting. Morning.
Morning, Chair. Christopher Fry, member of this committee.
Thank you. Those online?
Morning, everybody. Conrad Poole, member of this committee.
Morning.
Good morning, Chairperson Gillian Bosman, an alternate member of this committee.
Morning.
Good morning, members. Pamela Harris, alternate member to this committee.
Good morning. Good morning, Foreign Christians, member of this committee.
Morning. And then we just have an apology from Member Syed. He's just running a little bit late. I just want to check, Member Harris, are you standing in for Member Syed? Until he arrives?
Until he arrives.
Okay, thank you. I just want to make sure for voting purposes later. Is that all the members online? Okay, can I just ask that we'll start with the officials from DBE to please introduce themselves?
Thank you, Honorable Chairperson. I'm James Ndlebe from the Department of Basic Education.
Thank you so much. Okay, if there's no one else from DBE.
Thank you, Chairperson. Sorry, my name is Ms. Gela from the Department of Basic Education.
Thank you so much. Is there anyone else?
Good morning, Honorable Chairperson. My name is Ruwan Maada from DBE, Office of the Director General. Thank you.
Thank you so much. Okay, I don't see any other purple bubbles. Oh, Miss, there's a purple bubble there going.
Good morning. I'm Liesel Karalison, PLO for the Office of the DG Basic Education.
Thank you so much. Are those all the DBE officials? Okay, we can then start with the WCED officials then, if they can just please introduce themselves.
Good morning, Chairperson. It's Advocate Lynn Coleridge-Zoles online. Thank you.
Thank you so much.
Good morning, Chairperson. Good morning, members. It's Nombilo Malinga from WCD.
Thank you. Morning. Okay. Are those all the WCED persons?
That is correct, Chairperson.
Okay. That's fine. Then I just want to check, is Advocate Master online with us? Is he running a little bit late as well? Yes. Oh, he's online. Advocate Master, are you with us?
Morning, Chairperson and the members. I'm not running late with you. My name is Romeo, my surname is Master, and the legal advisor assigned to this committee. Thank you.
Wonderful. Thank you. I always appreciate it. Then we also have Ms. Hassan Musa and Mr. Daza in the committee room with us, just for the procedural advice in this regard. Okay. Members, I know some members haven't been through a negotiating mandate necessarily before, so I'm just going to take us all through it again. The matrix was sent to all the respective members. It is a lot. It was in a document that is online, and you can download the document onto your laptop, the folder, and it will go onto your folder. If you are here in the committee room, then you also have a physical copy of the matrix, which is in 3 parts. So what I'm going to do, members, I'm first going to take us through the matrix. Now, it is not possible for us to individually go through every single person of 5,445 submissions. However, there are many submissions that just indicate support or object, and there aren't that many that refer specifically to amendments. So what I'm going to do is I'm first going to take us through the matrix, indicating how the public feels in general, whether it's support or object. And the procedural officer is going to assist me in flighting that for us, but you also have it online. If the procedural officer goes a little bit too fast, please excuse it. It is a Word document, so it does lag a little bit on the system, but you also have it on the online version that she sent you. Just for if anyone from home is watching, we will also be sending the respective documentation to PMG afterwards, should they require it for their website. We will also be uploading the respective documentation for this meeting onto the WCPP website. So that's just for those who are watching from home. After I've taken us through the general matters for noting from the public where there are no amendments, I will take us through the amendments that have been proposed by the public, okay, from the stakeholders. Most of those are contained in annexures, and not all of them are in the matrix, because they, for example, sent a separate document. So where that happens, we will then go off the matrix document and go into the respective document if it is not contained in the matrix. Okay. Then what I'll do is I'll take a short break after we've done with the matrix, and then we will start with clause by clause on the bill. Now, members, because this is a negotiating mandate, I want to remind members that if we have two people who are proposing that fruit must be sold in schools, but the one wants apples and the other one wants bananas, there might be a situation where we can find a compromise and everyone wants to then sell pears. So if there's a situation where we want to negotiate on a particular clause or we want to consult each other, I will also today allow for short breaks so that negotiation can occur. And if people want to come to a compromise, that is possible. If not, that is also fine. There is members' prerogative how they want to vote on a particular clause. Okay. Once we have done the respective clauses, I will then put the bill, and then we will vote on the bill in its entirety. Okay, so your respective options on voting on clauses as well as the bill. So clauses, you can support a clause, you can oppose a clause, you can abstain to a clause, you can support with amendments, you can oppose with amendments. I just want to explain the amendment part quickly. If you support with amendments, it means that you want to amend this thing, but if the NCOP does not accept your amendment, then you will support the clause anyway. Okay, so just so that's clear. If you oppose something with amendments, it means that you want an amendment to a particular clause, and if the amendment is not brought, that you would oppose the clause anyway. Okay, so I just want to check online if everyone understands that part. Everyone's still on the same WhatsApp group. Okay, I'm going to take silence as tacit consent. And everyone here also seems to be happy with how that happens. Then when the bill is put, we are going to either support or object or abstain. Obviously, the amendments will then, if there are any amendments, those amendments then will be included, and then we will write with amendments, for example. Okay, everyone's still on the same page. Let me just have a look here quickly. Should we require legal assistance with drafting of clauses and or amending proposed clauses that are being made? We have legal online with us. If there are technical and procedural matters, we have both our procedural officer and senior procedural officer here in order to assist us. Okay, then members, I just want to check. I know that we said we're going to end at 1 o'clock, and I'm going to do my very best for us to finish by 1. But if we do not end at 1, I wanted to find out from you beforehand, are we then allowed to then take a break for lunch and for prayer, and then we come back at 2 o'clock? Would members be amenable to that if it comes to that? Because I would prefer us finishing today than calling you back on a different day. So I just want to get members' input on that. Member Fry?
Chair, I'm amenable to that. Let's get it done today, even if it means going over going over one and then reconvening at 2.
Okay, I just want to see what members online, how they feel. Obviously, I'll try my best to get us done by 1, but just in case.
Chairperson, yes, I concur with Member Fry.
Okay, thank you so much. Any other members' view on that? Member Christians?
Chair, I might have a problem, but I'll see how it goes.
Okay, again, like I said, I'm going to try my very, very best to get us done by 1. I just wanted to find out what members' diaries look like. Advocate Marsthorpe?
Chairperson, thank you. Just for what it is worth from my side, I have another meeting at 1:30, which may make me unavailable for a continued session. In fact, the 1:30 meeting was initially scheduled before your meeting for 10 o'clock. And because of this meeting and the relative short notice of this meeting, I made some representations for that meeting to be deferred to 1:30. Fortunately, that 1:30 suits the other members of the meeting. So let's see if you can certainly push for 1 o'clock. If not, I will have to seek someone's indulgence, either yours or the other meetings. Thank you, Chair.
No problem. If it does become a big problem, if we know we're close to finishing at 1, then we can always, I'll ask the members again whether they want to reconvene on a different day. But let's see if we can get it all done today. Okay. With that, Ms. Hassan Musa, if we can just flight part 1 of the matrix. So if you online members, if we can flight, you must open up your part 1 of the matrix. If there are submissions that are exactly the same, I'm just going to read the first one and then indicate where it is exactly the same. Okay, thank you so much, members. I just wanted to let you know, because the procedural officer is putting the matrix up online, I'm not able to see if you raise your hand. So if you do have a point of order, please just stop me by just saying chairperson, point of clarity or point of order and so on. Okay, let's start. Colleagues, I'm going to skip first annexures A to E, number 1 to 5 on matrix 1, because we will deal with the annexures afterwards. So we're starting with 6. Now, there are multiple submissions that read the exact same wording as number 6. So I'm just going to quickly go through number 6 for us. It is regarding the bill. It says it rejects the bill. It rejects specifically clauses 25, 35, 39. It calls for the inclusion of all ECD centers to benefit from the finances. Then it speaks to motivation of ECD being for lifelong learning and the foundation. It speaks to DBE wanting to nationalize ECD and be in charge of ECD. It speaks to and it motivates how ECD helps communities, jobs, small businesses. It motivates that all ECD should share in the 17 billion rand that the education department wants to spend on grade R. And then asking for ECD to be put into Bella, ran as independent businesses, owners be educational entrepreneurs to be supported, free to choose their curriculum. The registration must be made easier. They must not be closed. They must not be nationalized. It calls for the removal of clause 35. It says no to alcohol in the schools. I'm not to my knowledge that it's in the bill, but we can have a look at that later. Then clause 35 to stop abortion in schools. I don't think the clause reads like that, but we can have a look at that later when we start on the clauses. And then essentially supports the ACDC submission on the bill and learner pregnancy, which I'm sure member Christians will allude us to later. Then on page 2, that is number 7. Number 7 reads the same, so we're going to go to page 3. On number 8 and 9 reads the exact same. We're going to go to submission number 10 and 11 on the next pages. They read the same. 12, 13, 14, 15, 16 read the same. 17, 18, 19, 20. Okay, let me just quickly go to the next clause that reads differently. So colleagues, when I say that, please do make the assumption that all clauses read the same, but you also have the document in front of you just to confirm what I'm saying. Okay, then the next clause that reads different. Okay, the next clause that reads different is, not clause, the next submission that reads differently is number 44. So if members can go to 44. Okay. The person seems to be objecting to clause 2, dealing with penalty for parents. Seems to object to clause 4 and 5. Seems to object to clause 25, 35, 39. It wants the bill to cater for online and hybrid education. No details regarding ECD or registration for micro schools. And it wishes us to make amendments in these regards. Okay. So colleagues, just make notes for yourself that this particular submission calls for amendments. Okay. Then 45. There's no amendments in 45, but the person objects. 46. There are no amendments in 46. And to my knowledge, some of this is not in the bill. But it's an objection. 47. Objection, especially regarding homeschooling. 48 is just an objection. 49. 49 seems to read the same as 44, so object. 50 seems to read similarly, an objection plus some comments, no amendments there. 51, 52, objection. It does mention what it's objecting to, but there are no amendments. 53, objection, no amendments. Okay, then there are some that are exactly the same again. 54, those comment on the respective clauses. I don't see any amendments from 54 onwards to 60. 61, 62, no amendments but objections. Okay, the next page, 63 to 65. I don't see any amendments, but I do see comments on various clauses and objections. 66 to 68. All objections. I don't see any amendments. 69 to 78. Let's have a look. I don't see amendments, but I see objections. 79 to 83. Okay, so 79 and 80 are objections and comments. Then 81 is the support with amendments. The amendments that the person is proposing is regarding corporal punishment. Must be brought back. Discipline. Some comments related here. Okay, those are the rest are comments. Then, okay, 82 is just comments plus objection. 83 is a support plus amendments, it seems. Let me just have a look here. Oh no, these are comments. Okay. Then 84 to 88. Okay, the first three are objections. The 87 is a support with comments. 88 is an objection, or at least objection to those particular clauses mentioned. Then 89 to 93. '89 is a support. 90 does not seem to indicate, but it seems to be a support. 91, support. 92 is an abstain and makes comments on clauses. Then 93 is an agreement with comments. 94 is an agreement with comments. 95, agreement with comments. 96, agreement with comments. Okay. 97, agreement. Okay, comments there. 98, agreement. Comments. 99, objection with comments on various clauses. Most of these clauses seem to relate to the same clauses, so we will deal with that also when we get to the clause by clause. 101, objection and comments. 102, agreement with comments. 103, 104, objections with comments. 105, objection. 106 to 110 are objections. I don't see amendments there. 111, support. No amendment. Oh, wait, on the next page, amendments into clauses into management and administration. Okay. So that relates to the management administration of schools. Okay, so 111, ask for amendment. 112 and 113, support with comments. 114, oppose with comments. 115, support with comments. 116, reject. 117, does not indicate whether the person objects or supports, but it seems to object to public participation. 118, support with comments. 119, oppose. Okay, 120, oppose. 121, it doesn't seem to indicate, but it does seem to object to specific clauses. 122 to 124, objection. And there's a amendment request in 124 asking us to take clause 35 out. I think some of the others also spoke about objecting to 35 as well. 125, support. Okay, let's see. 126, 7, 8, objections. Let's see if there's amendments. Okay, it's comments on the clauses. 129, support with comments. 130, comment with objection. 131, 132, 33, 34 objections. No amendments. 135, objection. 136 is not clear, but it seems to refer to the increase of power of SGB. 137, objection. 38, support. 139, object. Also again refers to clauses 4 and 5. 140, objection, comments. 141, support with comments. Okay, 142, support. It has a proposed amendment to clause 8 at 142. Okay, So that members can have a look at later. 143. It's not clear, but it seems to be objections to clauses. 144, 145, support. No amendments. 146, objection, comments. 147, 148, support. 149, reject. No amendments. Speaks to various clauses. 50 and 51 speaks to various clauses and support. 52, 152, support with the requested amendment in the first bullet point at 152. I think that relates to clause 8. Okay. 153, 54, 55, 56, 57, object. I don't see any amendments there. 158, supports, no amendments. 159, objects. 160, supports. 61, rejects. 62, rejects. 163, reject. 64, object. 65, object. 166, reject. 167, support. 168, reject. Possible at 168, consideration to clause 8. 169, object. 70, object. 71, object, but it asks us to look at clause 9 at 171 regarding extension of HOD of 14 days and suspension. 172, reject. 73, object. 74, support. 75, support. Let me have a look here. 176, support. Okay, I don't see amendments there. 177, object. 78, object. 79, object. 180, object. There's a proposed amendment that we look at the definition of head of department. HOD definition. I suspect there may be a definition in the actual act, but we can have a look at that later. 181, object. 182, object. 183, object. 184, object. 85, object. 86, object. 87, object. Okay. 188, support. 189, object. 190, object. 191, object. 192, object. 193, object. 94, 95, 96, all objections. I don't see. 194 speaks to financial implications. Let me just write that down. Financial implications, as well as 195. Okay, rest of comments on that page. 197, oppose. 198, oppose. 199, oppose. Oh, 199 speaks to definition on special needs education. That might be a possible thing to consider. 200, object. 201, object. 202, support. 203, oppose. Okay, 203 is the first time that's spoken about procurement being centralized. So we need to have a look at that. What section is that now again? I'll have a look later. Okay. Then 204, oppose. Again, financial So that's finances included. 205, oppose. 206, support. It speaks to possibility to amendments to clause 8. 207, support. 208, object. 209, it's not clear. Seems to be comments in general. 210, support. 211, support. 212, seems to object, but it is not clear. Objections to certain clauses. 213, object. 214, object. 215, object. 216, 217, 218, objections. 219, objection. 220, objection. 221, objection. 222, objection. 223 and 224. Seems objections. 225, 26, 27, 28. All objections. I don't see any amendments there on that page. 229 to 235. Objections. There's one recommendation at 235 that must be funded, so that speaks to financial matters. 226, 236, sorry, to 239 are objections. I don't see amendments there. 240 to 242 objections. There's a 241, there's a proposal for clause 39. Clause 39, okay. 242 objections. 243 to 246. Those are, let me have a look here. Objections at 245. It asks again about financial implications. Let me have a look here. Okay, 247 to 250 are all objections. No amendments. 251 to 253 are objections. I don't see amendments. 54, support. I don't see an amendment. 255, objection, I think. Let's see. Actually, we can just leave that one open. We can just say not indicated, but it is objection to specific clauses. Then 256, objection, multiple clauses. 257, 258, 59, objections. 260, support. No comments. 261, objection. 261 again speaks about finances. 262, objection. 263, objection. 64, object. 65, 66, 67, all objections. I don't see amendments there. 268, 69, 70, 71, 72 objections. I don't see amendments. 273, 74, 75, 76, 77 objections. Oh, at 277, it asks us to include online and hybrid in education. Online and hybrid. Okay. 278. Objection. 279. 280. 281. 282, 283, objections. Look here. 284. It says procurement, but it doesn't say what about procurement. 285, also objection. Look here. 286. That speaks to finances. And it asks us for a financial cost analysis, but that's also finances. 287, objections. 288. Objections to specific clauses, but not clear whether it's an objection to the bill. 289, objections. Evictions from farms do not fall part of education, but there is a proposed amendment at 289, but it does not fall within the mandate of education. 290, 291, 292, objections. 293, objection. 294, 295, support. Let's just have a look at these amendments. In 295, there's amendment regarding clause 39. Okay. 296. Not clear, but it seems to be an objection. 297. Objection. 298, support. No amendments. 299. Seems to be an objection, but does not specifically indicate. 300. Objection. 301. 302. 303. 304. 305, objections. 306, support. No amendments. 307, objection. And person used the word disagree, which is also an objection. 308, objection. At 308, it asks for online and hybrid education to be included. Included. And then at number 5, it asks us to say in consultation. Okay, then multiple people mentioned that ECD not included, so that might be general matters not included in the bill. Multiple people mentioned that. 309, object. 310, object. These are exactly the same written in terms of the respective amendments as the ones I just mentioned. 311, objection. 312, object. 313, object. 313 specifically objects to the CS not being procedurally sound. Not procedurally sound. The other amendments have already been proposed. Okay, I'm not going to go through all those amendments. I've already mentioned them in some others. 314. Object. 315. Object. 316 and 317. Object. Let's just have a look at 317. It's a long paragraph. Okay, those are general objections to clauses. 318, similarly written to the previous matters. 319, object 320, 21, 22, 23. Okay, can we just ask that everyone online just please mute unless you're calling for a point of order or clarity? Thank you. 322, 323, 24, 25, 26 objections. I don't see amendments. 327, 328 objections. Let me just quickly read this. This is in Afrikaans. Yeah, I don't see any amendments. 329 doesn't have a name, but they wrote object. 330, 331, 332 objections. 333, 334, 335, 36, 37 objections. 338 until 345 objections. 646 to 347 objections. 347 is written in the same manner as previous members. 348, 349 objections. 349 looks like there might be stuff here. Okay. No, that's just a copy and paste of the Constitution. 350, objection. 351, 352, 53, 54, 55, 56, 57 objections. 358 is an objection, but they specifically also quote subsections of clauses 35 as well as the CS regarding limits. Okay, so that's 35 and CS. Those are new subsections quoted. 359, 360 objections. 361 until 367 objections, written in similar manner as previous matters. 368. Until 370 are objections. I don't see amendments. 371. Until 377 objections. I don't see amendments. 378. 378 has amendments written similarly as previous matters. That's regarding homeschooling and ECD. 379. Until 386 objections. 387. Until 391 objections. 392 is support. But objection, wait, let me have a look here. Oh, okay. It includes comments regarding registrations. Then 333. Until 399 are objections. $400. Until 404 are objections. 405. Until 413 objections. 414. Until 419 objections. 420 support. But it also asks us to look at online learning, online admission. Okay. Oh, sorry, it's online submission, not online learning. Okay. Then 421. Until 431 opposite. I'm reading the words here. Objections. Or 32 objection, 432 until 435 objections. 435 specifically refers to the Pestalozzi Trust submission, but we'll get to those later. 437 until 447 objections. 448 until 456 objections. 457 until 467 objections. 468 until 483 objections. I did not know that the online system allowed for emojis, but there are some emojis there on that page. 484 until 490 objections. 491 seems like support, but it doesn't indicate specifically. 492 until 498 objections. 499 objection. 500 speaks to finances. Okay, 501 until 511 objections. 512 until 525 objections. 526 until 537 objections. 538 until 556 objections. 557 until 578 objections. 579 until 593 objections. 594 until 614 objections. Yes. Okay. 615 objection. 615 until 632 objections. 633 until 646 objections. There are one or two that doesn't indicate. They just write that is crazy. 647. I think some of the people on this page misspelled no and said NA, but 647 until 661 objections. 662 to 667 objections. 678 to 698 objections. 699 to 716 objections. 717 to 733 objections. 734 until 748 objections. 749 until 754 objections. 755 doesn't indicate view on bill, but agrees with some of the amendments and that some of that can be improved, but doesn't speak to what specifically, just refers to level of education standards dropping. 756 until 766. Objection 767. To 783. Objection 784. Until 797. Objections 798 is unclear, just says what language the person speaks. 799 to 802. Objections 803 until 813. Objections 814 just wrote to good, so I'm assuming that's support. 815 to 820. Objections 821 to 837. Objections 838 to 851. Objections 852 to 865. Objections 866 to 879. Objections 880 to 887. Objections 888 to 902. Objections 903 to 916. Objections 909 speaks again on financial matters. Okay, 917 to 936. Objections 937 to 952. Objections 947 only indicated their respective denomination. 953. Objection 950. Let me just look here. 954 to 960 says objections. I think 962 must have been an oral submission because the person just wrote as stated. 963 to 967. Objection 968 until 983. Objections 984 to 1002. Objections 1003 until 1006. Objections 1005 said not applicable. 1007 just said I don't think it's positive. I think we can interpret that as an objection. 1008 to 1021. Objections 1022 speaks to finances. And I think that's the first comment relating the National School Nutrition Program. National School Nutrition. Okay. 1023 to 1030. Objections 1031 to 1047. Objections 1048 to 1060. Objections 1061 To 170 objections. 1071, sorry, asked for home language and school speech. It doesn't indicate view. 1072. To 1094 objections. 1095. To 1097 objections. 1098 doesn't indicate view, it just says it is stupid. 1099 to 1100 objections. 1101 also says it's stupid. I think we can interpret that as objections. 1102. To 1110 objections. 1111. To 1128 objections. 1129. Objection 1130 relates to clause 8 and the pros and cons to clause 8 that the person wishes us to consider. 1131 to 1133 objections. 1134. To 1155 objections. 1156. To 1166 objections. 1167 said to be confirmed. 1168. To 1171 objections. 1172. To 1182 objections. 1183. To 1204 objections. 1205. To 1219 objections. 1220. To 1236 objections. 1237. To 1255 objections. 1256. To 1279 objections. 1280. To 1296 objections. 1297. To 1310 objections. 1311. To 1327 objections. 1328. To 1344 objections. 1345. To 1346 objections. Oh, 1347 is also objection. Sorry, the wording was a bit complicated there. 1348. To 1366 objections. 1367. To 1383 objections. 1384. To 1390 objections. 1391 said not applicable. 1392. To 1397 objections. 1398. To 1405 objections, 1406. To 1416 objections, 1417. To 1426 objections, 1427. I don't think that one is related to our province. 1427, Port Elizabeth. Then 1428. To 1441 objections, 1442. To 1459 objections, 1460. To 1479 objections, 1480. To 1494 objections, 1495. To 1516 objections, 1517. To 1534 objections, 1535. To 1538 objections, 1539 support, 1540 not applicable, or it might be no, might be someone who spelled it wrong. 1541. To 1549 objections, 1550. To 1558 objections, 1559. To 1578 objections, 1579. To 1595 objections, 1596. To 1606 objections, 1607 is unclear, just wrote PR. 1608. To 1611 objections, 1612. To 1630 objections, 1631. To 1643 objections, 1644. To 1658 objections, 1659 objections, 1660 just said see above, and the above was this is a pot of crap. I think crap was spelled wrong, but okay. 1661. To 1673 objections, 1674. To 1678 objections, 1679. To 1695 objections, 1698 said NA. It's unclear whether they meant to say not applicable or no. 1697. Until 1699 is objections. 1700 as the first line speaking to clause 8 regarding amendment. 1708. To 1712 objections, 1713. To 1719 objections, 1720 to 1722 is unclear as it's either not applicable or no, could be either. 1723 to 1733 objections, 1734 to 1747 objections, 1748 to 1757 objections, 1758 to 1773 objections, 1774 says the bill has not been widely advertised, but we will mention our separate public participation procedures to the NA and the NCOP later when we get to the negotiating mandate. 1775 to 1792 objections, 1793 to 1811 objections, 1812. Okay, 1812 is quite long. Okay, it mostly quotes the Constitution. Okay, 1812 was an objection. Okay. 1813 to 1823 objections, 1824 to 1833 objections, 1834 to 1839 objections, 1840 to 1846 objections, 1847 is unclear, just has a full stop, 1848 all the way down to 1877 objections, 1878 all the way down to 1903 objections, 1904 to 1914 objections, 1915 said not applicable, 1916 all the way down to 1937 objections, 1938 okay, 198 speaks to grade R. Okay, the rest are general objections to clauses. 1939 okay, that's similarly written. All the way down to 1952 objections, 1953 all the way down to 1977 objections, 1978 all the way down to 2001. Objections. 2001 speaks to grade R not being financially viable. Grade R finances. Let me just see where that one ends. Colleagues, we are at 2001, and I ask that we please take a 5-minute break. That's mostly for me and having to make sure that we table the respective matrix. Okay, I'm gonna assume silence is consent. We're taking a 5-minute break. We don't need to put the sign up on the system. We can just maybe mute everyone. all the way down to 2343 objections, 2344. Two, 346 objections, 2347 is asking about the definition of a center is in the bill. I think that's the first time that is mentioned specifically. Two, 348. To 2357 objections, 2358. Two, 358 seems to suggest options for amendment on homeschooling. And ask about the costs regarding a competent assessor. Okay. Also an objection 2359. To 2366 objections, 2367 has a paragraph regarding the SAYAS and the costing. But that has also been mentioned before. The matrix referred in, I think, relates to the NA. Two, 367 on the next page actually includes an actual amendment with a quote for possible amendment that is regarding definitions of basic education. Okay, so there's an amendment there we have to pay attention to. Have a look here. It also proposes an amendment regarding home education definition. On the next page, there's also an amendment proposal in the fourth sentence regarding grade 1 and the age. There's a request for amendment in clause. Which clause is this? This is clause 3. Okay. Clause 4, the person makes a proposal for amendment regarding age. Just earmark this page for later. Clause 5, it just advocates for the removal of the clause. There's no amendment there. Okay. Then 2 pages later, the same person makes recommendations regarding independent micro schools. Independent micro schools. Okay, sorry, it's just a very long submission. I'm just trying to make sure. Okay. All various comments from same person. Various objections to clauses from same person. Next page, where it speaks to clause 16, same person, they are making a proposed amendment to section 16 to, it says some in consultation that they want. In consultation. Okay. Okay. I'm very impressed by the extent of that submission. 2368. To 2383 objections. Then we are at the end of pile 1. Okay, we are essentially more or less halfway. We will now move on to your second batch. It will be titled Part 2. Okay, is Part 2 up? Number 1 to 13 are annexures. We'll get back to those. 14. To 38 objections. 39. To 40 objections. 41 makes a proposal for amendment to, let's have a look here. I think this is general inclusion that they want of those words. Okay, they also speak about the finances in grade R. Okay, this is another long submission. Okay, that's an objection. 42. To 45 objections. 46 support. Okay, the various sections and the amendments are then in that particular one indicated. Okay, 47. To 53 objections, 54. Okay, 54 at the subsection 3, the person is proposing in homeschooling to allow the inclusion of tuition by grandparents. I suspect SASA already deals with a guardian, which may include grandparents, but we will check that when we get to the clause by clause. Let me have a look here. Okay, essentially this is an objection. 55. To 62 objections. '63. To 78 objections. '79. To 85 objections, 87. '88 is a comment. 89. To 100 objections, 101. Until 104 objections, 105 objects, but 105 also asks whether home education is considered an educational institution. So that's just a question for later for the department. Then '106. To 108 objections. '109. To 128 objections, 129. I think that's the first time someone speaks about cabinet instructions were not followed when developing and distributing SAYAS. So that's cabinet instructions, and then it goes on to speak about the SAYAS. It also speaks to the SAYAS not being distributed to the public. I know it was on our committee documents when we received it. But to my knowledge, I'm not sure whether that was distributed, as the SIA is something that is introduced before legislation by the department. $130. To 153 objections. $153 seems to be written similar to the previous lengthy submission that I mentioned now. 154 to 158 objections. 159 is the same lengthy one. 160. To 180 objections. 181. To 196 objections. 197. To 222 objections. To 23. To 250 objections. 251 seems to be from someone from the Eastern Cape, but similarly indicates objection. 253. To 270 objections. 271.
Chairperson,
Hello, who's speaking?
it's Pamela Harris.
Hi, Member Harris.
196. It seems it's either KZN or Gauteng. That is what the comment says is where they attended as well.
Let me just have a look here.
Randfontein.
196. 196.
My wife and I attended the public hearing in Randfontein, Gauteng. So
Okay,
clearly
let's
it's
have a
not
look
within
here.
our.
Is that in the second pile? Let me have a look. Oh,
Yes,
here
in
we
the,
go.
yeah,
Here we go. Okay,
yeah, the one that's
196
here.
seems
Yeah.
like it's Gauteng.
Yeah.
Okay, no problem. Thank you so much. Where were we? We were at. Now I lost my train of thought. Yes, I'm at this lengthy submission now on page. Look here, which is this number of the submission. I'm at 293 at this lengthy submission. Okay, that's all objections. Then after that, 293. Okay, there's no amendments here. Let's have a look here. To 311 objections, 312. To 325 objections, 326. To 347 objections, 349. To 374 objections. This is the first time by 374 where someone speaks about the central procurement and it being one size fits all. Okay. Okay, 375. To 457 objections. Okay, 457 is a copy and paste from the Constitution. 458. To 535 objections. $536. To 552 objections. 553. To 573 objections. 574 is the first time someone refers to the billable not being in line with the white paper. Billable not in line with white paper. Okay. For those who don't know what the white paper is, you get a white paper and a green paper before legislation is introduced. That often has research in it as well, and that's introduced usually by the department. But that's a layman's explanation of it. 574. 575. until 592. Objections and a few extra emojis on that page. 593 until 595 objections. 596 support. 597 objection. 598. I'm not sure that's an objection or support because this is not relating to an actual amendment in the bill. It relates to the act, to my knowledge. 599 to 601 objection. 602 similarly, it's unclear whether that is an objection to the bill or support of the bill, as the clause relates to the original act. We can always have a look at that later. 603 to 612 objection. 613, it's unclear. 614 and 615 objection. 616, I think that is support. Okay. 616, yes. 616. 617. To 627. No, until 626. Have a look here. No. This is to, let's have a look here. Until 625. It's until 625. It's objections. 626. Unclear. It makes comment on general resources. 627 support. 628 I'm interpreting as a support. 629 I'm going to interpret as a object. It just says why is it even here. 630 object. 631 is a comment regarding salary. 632 objection. 633 Namakwa municipalities in the Northern Cape, right? That's right. Okay, so 633 is not Western Cape. 634 is also not Western Cape. 635 to 640 objection. 641. Okay, I'm interpreting that as an objection. It's regarding finances. 642 support. 643 is a comment regarding salaries, but it could be interpreted as a support. 644 until, let's have a look here. 646 support. 647 objection. 648 is a comment. 649, it's unclear, just says it will help us to have our voice heard. I'll interpret that as a support. 650. $650 is unclear to me. I just ask a question regarding whether independent site centers can be changed so that the Department of Education can pay them under the Department of Education. So 650 is unclear to me. 651 to 654 support. 655 objection. 656 support. 657 objection. 658 support. 659 660 661 support. 662 says not applicable. 663 and 664 I'm interpreting as support. 665, and those all relate to grade R becoming compulsory. 665, object. 666 and 667, support. 668, objection. 669, support. 670, it doesn't say, but I'm interpreting that as an objection. 671, support. Not support, objections. 672, 673 and 674 I'm interpreting as support. 675, until 677 I'm interpreting as support. 678 and 679 object. 680, support. 681, objection. 682 just is essentially a copy and paste of the preamble of the bill, so I'm not sure, that could be interpreted as support. 683, objection. 684 seems to only support the grade R for teachers more than 15 years. So that's a proposed amendment. Okay. 685, support, but objects to the learner pregnancy and merger of schools. 686, support. 687 and 688, objections. 689, support. That relates to the teacher specifically. 690, support. 691 until 693, objections. 694 until 696, support. 697 until 701, objection. 702, support. 703 to 704, objection. 705 is support. 706 until the end of the document at 995 is objections. Members, we are done with pack number 2. We're almost there. Okay. We are now moving over to part 3. You can load up part 3, and it does feel light as well. Okay. Again, members, I'm going to ignore the annexures for now, as we'll get back to them. The annexures are up until number 12. Then we're starting at number 13 in pack 3. It starts with objections all the way down to, let's have a look here. (147) objections. 148. to 179. Objections 180. Okay, 180 makes the recommendation that when regulations are made, that there must be input from members of the public and parents. Then in that same submission, there's a complaint regarding special needs not being included in grade R. Okay, that's an objection. Then 182. To 221 objections. 222. Nice to have seen a shout out of my name there. To 251. Objections with a few extra emojis. 252. So did I miss one?
No, I just want to make sure. 222
222.
is a. Okay, no, I just want to make sure.
Because it goes on to the next page.
So it's almost being Smith.
Oh, okay. No problem. Okay, I ended at the page with the fun emojis. Then 252. Until 256. Objections. 257. People have previously talked about the curriculum, but I think this is the first time asking for the removal regarding the section. Okay. Then 258. Until 276 objections, a few extra emojis on that page. 277. To 302 objections. 303. To 328 objections, but 328 reads Humansdorp, so that's not Western Cape. Then 328. To 335 objections. 336. I just want to check Matlosana. Is that in the Western Cape? Okay, so that's not in the Western Cape. Okay. 337, another Deirdre there, somewhere in the Western Cape in Bito. To 364 objections. 365. To 382 objections. 383 Emma Gleni. That's not in the Western Cape, that's in Gauteng. But it is a comment regarding single mom, too much expenses. 384. To 421 objections. 422. To 427 objections. 428. I don't think is no, that is Western Cape. It says there next to it Plet. Okay, so that is Western Cape. Okay. 429. To 432 objections. 433 is unclear whether they meant not applicable or no. 434 objection. 435 unclear whether they meant not applicable or no. 436. To 482 objections. 483. To 514 objections. 515. Of 519 is not in the Western Cape. 520. To 540 objections. 541 is mixed. It says it agrees with some amendments, but the level of education standards are dropping and this must be improved. 542. Until 555 objections. 556 is from Johannesburg. So that's excluded. 557. To 599 objections. 600 road goods. I'm assuming that's support. 601. To 613 objections. 614 Paris is in the Free State, right? Okay, so that one doesn't count there. But thank you for the input. 615. To 646 objections. 647 is unclear. There's just a full stop. 648 and 649 objections. 650 is not in the Western Cape, no? Okay. 651 I don't think is in the Western Cape either. Yeah. 652 to 654 objections. 655 is not in the Western Cape. 656 To 661 objection, 662 is not in the Western Cape. Yes. 660 is also not in the Western Cape. Sorry, 660 is also not in the Western Cape. Then 663. Until 669 objection, 670 is not in the Western Cape. 671. To 681 objection, 682 not in the Western Cape. 683. To 687 objections, 688 not in the Western Cape. 689 objections, 690 not in the Western Cape. 691. To 699 objections, 700 not in the Western Cape. 701. To 705 objections, 706 not in the Western Cape. I missed one.
It's not in the Western Cape.
702 is also not in the Western Cape. 702 and 706. Okay, then we had 707. Until 711. Objections 712 not in the Western Cape. 713 to 715 objections, 716 not in the Western Cape. 717 to 719 objections, 720 not in the Western Cape. 721 objections, 722 not in the Western Cape. 723 objections, 724 not in the Western Cape. 725. That's the West Coast. Early Beach, Overberg, okay. Until 727 objections, 728
Sorry, Chair.
Chatsworth in the KZN.
I'm assuming
Then
it's
729, I also think it's in KZN.
Yeah, but there's a Chatsworth in on the N7 as well. So, but I
Greater
don't think
Chatsworth.
I don't think that's Greater Chatsworth. So I think it's not in the Western Cape.
Okay, we'll just check on that. Check on 728. Then 729, not in the Western Cape. I think Helbron, where's that? Not in the Western Cape. 731. Edendale. It's by Matikama area. Okay. Until 735 objections. 736 Umloti. No. Okay. Not in the Western Cape. 737. To 742 objections. 743 not in the Western Cape. 744. And 745 objections. 746 not in the Western Cape. 747. To 756 objections, 757 not in the Western Cape, 758 not in the Western Cape, 759. To 765 objections, 766 not in the Western Cape, 767 and 768. No, sorry, 766 and 768 not in the Western Cape. Then 769 to 772 objections, 773 not in the Western Cape. 774 to 778 objections, 779 not in the Western Cape. 780 To 791 objections. I think 791 is an objection, but until 790 then. 792 not in it's not in the Western Cape, it's Gauteng, no? Okay. 793. Where's 800? No, I mean where is that? In Durban. Okay, so until 799 objections, 800 not in the Western Cape, 801. So 809 objections, 810, it's unclear whether they meant not applicable or to write no. 811. To 831 objections. Where's Newcastle? Okay, 832 not in the Western Cape. 833. To 838 objections. 839 not in the Western Cape. 840. To 876 objections. 877 not in the Western Cape. 878. Until 887 objections. 888 not in the Western Cape. 889. To 832 objections. 833. To not wait. To 955. 954 objections. 955 not in the Western Cape. And 953 just said to be confirmed. 956. To 961 objections. 962 not in the Western Cape. 963 not in the Western Cape. 964. To 998 objections. 999. To 1006 objections. 1007 said I don't like it, which I'll interpret as an objection. 108, 1008. To 1014 objections. 1015 is unclear, just says I don't need to give a reason why. 1016. To 1071. Objection 1072, not in the Western Cape. 1073. Secunda.
No.
To 1082 objections, 1083, not in the Western Cape. 1084. Where's Omfolozi? Okay, to 1087 objections, 1088, not in the Western Cape. 1089, just said as below. 1090. To 1102 objections, 1103, not in the Western Cape. 1104, not in the Western Cape. 1105. To 1130 objections, 1131, not in the Western Cape. 1132 to 1136 objections, 1137, not in the Western Cape. 1138 Where's the Gama Park? Is the Gama Park in the Western Cape?
I think so.
I think we must check that one. That is 1163. So until 1162 objections, 1163, we just need to check location. 116, is it?
It says it's a sub.
Okay, then it's 1163 objection, 1164. To 1174 objections, 1175, not in the Western Cape. 1176 objection, 1177 said not applicable. 1178. To 1193 objections, 1194 just said none. Not sure if they meant to say no, so we'll not interpret that one. 1195. To 1201 objections, 1202, not in the Western Cape. 1203. To 1208 objections, 1209, not in the Western Cape. 1210. To 1212 objections, 1230, not in the Western Cape. 1240, not in the Western Cape. 1215. To 1247 objections, 1248 is just a full stop. 1249. To 1256 objections, 1257 not in the Western Cape. 1258 not in the Western Cape. 1259. Objection 1260 not in the Western Cape. 1261. To 1290 objections, 1291 not in the Western Cape. 1292, not in the Western Cape. 1293. Objection 1294, not in the Western Cape. 1295, not from the Western Cape. 1296 to 1307. Objections. 1308, not in the Western Cape. 1309, not in the Western Cape. 1310 to 1312. Objections. 1313, not in the Western Cape. 1314, not in the Western Cape. 1315 to 1318. Objections. 1319, not in the Western Cape. 1320. Objection up until 1322, 1323, not in the Western Cape. 1324. Objection 1325, support. 1326, not applicable. 1327 until 1331. Objections 1332, not in the Western Cape. 1333 seems to agree with grade R in principle, but not regarding the financial means or funding. Financial funding cost. It speaks to criminalization. Okay. 1334. To 1350. Objections 1351, not in the Western Cape. 1352 and 1353. Objections 1354, not in the Western Cape. 1355 and 1356. Objections 1357, not in the Western Cape. 1358, not in the Western Cape. Vredendal. Is it in Matsenkama, right? Okay. 1359 to 1362. Objections 1363, not in the Western Cape. 1364, not in the Western Cape. 1365 to 1368. Objections. Is Lutzville in the Western Cape? Okay. 1369 to 1371. Objections. 1372, not in the Western Cape. 1373 to 1384. Objections. 1385. Germiston's not in the Western Cape. 1386 to 1398. Objections. 1399, not in the Western Cape. 1400 to 1404. Objections. 1405, not in the Western Cape. 1406 to 110. Objections. 1411, not in the Western Cape. 1412 to 1426. Objections. 1427, not in the Western Cape. 1428 and 1429. Objections. 1430, not in the Western Cape. 1431. Objection 1432, not in the Western Cape. 1433. Objection 1434 is not in the Western Cape now. Okay. 1435. Objection 1436 objection, 1437 not in the Western Cape, 1438 objection, 1439 not in the Western Cape, 1440 to 1452 objection, 1453 not in the Western Cape, 1454 to 1460 objections, 1461 not in the Western Cape, 1462 excuse me, until 1481 objections, 1482 not in the Western Cape, 1483 objection, 1484 not in the Western Cape, 1485 to 1488 objections, 1489 and 1490 not in the Western Cape, 1491 to 1493 objections, 1494 not in the Western Cape, 1495 there's a few not applicables as well. To 1511 objections, 1512 not in the Western Cape, 1513 to 1518 objections, 1519 not in the Western Cape, 1520 objection, 1521 not in the Western Cape, 1522 not in the Western Cape, 1523 to 1530 objections, 1531 not in the Western Cape, 1532 not in the Western Cape, 1533 to 1538 objections, 1535 is a little bit ambiguous because it says supporting the bill will rub out children of decent education. I think they meant to write object, so I'll interpret that as such. Then 1539 not in the Western Cape, 1540 and 1541 objections, 1542 not in the Western Cape, 1543 to 1546 objections, 1547 not in the Western Cape, 1548 to 1552 objections, 1553 not in the Western Cape, 1554 where's Blanco, to 1561 objections. It is unclear whether Blanco is in the Western Cape, 1562, then 1563 to 1574 objections, 1575 not in the Western Cape, 1576 objection, 1577 not in the Western Cape, 1578 not in the Western Cape, 1579 objection, 1580 not in the Western Cape, 1581 objection until 1584, 1585 not in the Western Cape, 1586 not in the Western Cape, 1587 to 1594 objections, 1595 not in the Western Cape, 1596 to 1601 objections, 1602 not in the Western Cape, 1603 not in the Western Cape, 1604 Objection 1605, 06, 07, not in the Western Cape. Silvertown?
Yeah.
Cape Town. Athlone, yeah. 1607, sorry, 8. Objection 1609, not in the Western Cape. 110. Objection 1611, also objection 1612, not in the Western Cape. Yes, that's the Eastern Cape, no? Gauteng, okay. 1613, not in the Western Cape. 1614, not in the Western Cape. 1615, not in the Western Cape. 1616, objection 1617 and 1618, not in the Western Cape. 1619, objection 1620, not in the Western Cape. 1621, objection 1622, not in the Western Cape. 1623, objection 1624, not in the Western Cape. 1625. To 1654, objections 1655, not in the Western Cape. 1656. Yes.
Just 1647 is also not.
Okay. 1647, also not in the Western Cape. Thank you for that. 1656. Dana Fontaine, West Coast. To 1663, objections 1664, not in the Western Cape. 1665, not in the Western Cape. 1666, 1667, not in the Western Cape. 1668 to 1671, objections 1672, not in the Western Cape. 1673, not in the Western Cape. I don't think that's in the Western Cape. 1674 and to 1676, objections 1677, not in the Western Cape. 1678, objection 1679, 1680, both not in the Western Cape. 1681, objection 1682, not in the Western Cape. 1683. To one, sorry, that's just the typo that the person made. To 1708, objections 1709. Did I miss one? 17. Oh, sorry, Secunda. 1703, not in the Western Cape. Until 1708, objections 1709, not in the Western Cape. 1710. To 1742, objections. Did I miss one? Where did I miss one? 171. George.
Yeah.
It will, that one, okay, sorry, support. 1715, thank you for that. 17, where was I? 17. For two objections up until there. 1743, I don't think that's in the Western Cape. 1744, objection. 1745, not in the Western Cape. 1746 until 1751, objections. 1752, not in the Western Cape, up until 1754, not in the Western Cape. 1755. To 1759 objections, 1760 not in the Western Cape, 1761. Westfontein is, yes. One up until 1788 objections, 1789. Until 1827 objections, 128. Ag nee man deurdry. 1828. To 1848 objections. Let me just have a look here. It's a long section here. Okay, those amendments we've already read in previous proposals. 1849. Philadelphia. Hillview.
I think it's done.
Okay, until 1860 objections. 1861 not in the Western Cape. 1862. Until 1873 objections. 1874 not in the Western Cape. 1875 qualifies because they're also in Plettenberg Bay.
Yeah.
Okay. One 1875 until 1892 objections. 1893 not in the Western Cape. 1894 not in the Western Cape. 1895 objection. 1896 not in the Western Cape. 1897 to 1908 objections. Let me just have a look. Yeah, okay. 1909, not in the Western Cape. 1910. 1928 objections. 1929 is unclear whether it supports or objects. It just mentions a clause. 1930. 1935 objection. 1936 says there's a gray area between clauses 6 and 7. So we'll have a look at that later. Just earmark that for yourself. 1936. 1937 objects. 1938 support. 1939. 1954 objections. 1955 seems unclear, speaks to salaries. 1956 objections. 1957 objection. 1958 support. 1959. 1968 objections. 1969 support. Okay. 1970 support. 1971 and 1972 objections. 1973 is asking a question about salaries. 1974 object. 1975 is not in the Western Cape. 1976 is not in the Western Cape. 1977. To 1983 objection. 1984 support. 1985 asks that grade R teachers get the salary they deserve. 1986 support. 1987 and 1988 support. 1989 object. Until 1992 are objections. 1990 actually is unclear. Okay, then 1993 support. 1994, 5 and 6 support. 1997. Is object. 1998 support. 1999 sorry. Okay, 1999 object. 2000 support. 2001, 2002, 2003 support. 2004 unclear. 2005 seems contradictory. They seem to argue for the objection to some clauses and the support of others. 2006 support. 2007 object. 2008 support. 2009 support. 2010 object. 2011 support. 2012 to 2013 object. 2014 seems to speak about teachers becoming permanent. I'll interpret that as support. 2015, 16, 17 support. It should be noted that CPUT is higher education and does not fall within the basic education mandate in 2017. 2018 support. 2019 seems to support, but it only mentions asking teachers to become permanent. 2020 object. 2021 object. 2022 support. 2023 object. 2024 support. 2025 object. 2026 support. 27 support. 28 support. 2029 and 2030 object. 2031 32 support. 2033 34 35 object. 36 37 38 support. 39 40 41 object. 42 no comment. 2043 support. 44 support. 2045 and 46 object. 2047 support. 2048 object. 2049 and 2050 object. And members, without the annexures, that brings us to the end of document 3. Should we take a 5-minute break and then deal with the respective annexures? Thank you. that the function of the SGB not be substituted by the HOD. Okay. Seems to object to clause 5. Quotes 2 court judgments there. Okay, it's the interpretation of the court judgment, clause 7, C and D. They speak about the exemption from the code of conduct being too wide, the just cause shown, and can lead to abuse. They interpret the wording best interests of the learner in 7D, clause 7D, and that the provision ignores other factors. Clause 14 regarding central procurement. They say that although the procurement is to be done in consultation with the SGB, the proposed amendment is in conflict with the entire purpose of the functions of the SGB under SASSA. And it seems that if we consider an alternative provision, they want the SGB to be able to apply to the HOD for centrally procured identified learning and support material. Clause 19 regarding the dissolution of governing body. Oh goodness, what did I do now? Sorry. They say that the period of governance by an interim body should not be longer than 3 months, within which period an election for a new governing body should take place, because the democratic principles of the election of the governing body should be restored as soon as possible after the dissolution of the existing governing body. And then it's the conclusion, and that's the end of the document. Then Annexure E, and then we're done with the annexures for section 1. Just for the record, we're not going to go through Annexure B because the FETSAS one was the one in the briefing meeting that they did with us. Yes, okay. And just for the record, they did object as well. Annexure A will do when we do clause by clause because WCED is also in the meeting. That's okay. Almost done. Okay, this is from, who's this from? Ms. Van die Kerk, okay? This is a letter objecting to the bill, specifically clause 35, which I think is the regulation. No, it's homeschooling. It's homeschooling, okay? Okay, so there's her motivation. She mentions specific clauses regarding a competent assessor. Okay. She references some clauses in the original SASSA. That's not in this bill, but it's in the original act. She continues with motivations. She references the SIAS. Okay, I think I've seen a similar submission in one of the matrices to this wording. She's concerned regarding fields of expertise and qualifications. She's concerned regarding one size fit all, curriculum freedom. Okay, I think this is in line with the Pestalozzi Trust. I think this is what the submissions were probably referring to. Okay. Okay, thank you so much. Those are items we've also dealt with in the matrix. Then we can go to matrix 2's annexures. We'll start with annexure A. But essentially the annexures in number 1 were objections. Okay. Annexure 2. Okay, we had annexure A at matrix number 2. Almost done. Okay. This seems to be a petition. The procedural officer will just have to check first because she says on behalf of parents and concerned citizens of Gauteng and all the other provinces of South Africa. So I'm not sure if she specifically relates to the Western Cape or if she's just speaking in general, but we'll go through the items. These are many similar items to what was in the matrix. She references the Principal Act relating to criminal sentences. Objects to clauses 4, 5. Ask questions about 25. Wants less stringent measures in 33 regarding the registration of independent schools. It opposes clause 39. It references committee meetings that are not in the Western Cape. It references NCOP matters. References financial matters of the clause 2. References some transport matters in KZN. Clause 35, I'm not sure whether those figures are correct. It might be in the respective province where it is. speaks about a public participation process being flawed, but it seems to reference national parliamentary matters. Yes, I think this is reference to national parliament. It again just says Gauteng and all the other provinces of South Africa, so I'm not sure if the facts in here are relevant to Gauteng specifically or to the Western Cape, as it's quite broad. References NCOP matters again. It references billable translations. Okay. This is Zulu is not the official language of the Western Cape. There has been Xhosa translation at public hearings, but we don't print the bill. It's not, so the bill is in the language we receive it. So that's why it's in English. I think that's related to national parliament matters. Okay. Yeah, these screenshots seem to relate to national parliament matters and departmental people. Okay. We can go on to the next one. Mr. Jusab, Ishmael Jusab from the Evia de Klerk Foundation. Okay, so this is a letter we received from the Evia de Klerk Foundation, sorry. Okay, that's context. I think this was after the opportunity for oral expert briefings, I think. They quote public participation. They quote some constitutional sections. They speak about the admission policies and that this may, that the, let's have a look here, that it will override powers of the SGB based on equality and equity. It indicates that the bill discriminates against undocumented learners through the inclusion of the definition of required documents. I think that's a new matter that they're bringing. I haven't seen that in other submissions because not everyone has the same access to documentation. They quote a ruling there. They indicate their concern regarding criminalization of parents in Section 3, Clause 3, sorry, regarding non-compliance of attendance, arbitrary arrest and detention, right to education. They mention some other rights there. And they indicate their concerns regarding the criminal sanctions. They submit that the unconstitutional consequences of the bill can be avoided by altering and or altogether forging certain provisions relating to decision-making powers of SGBs and parallel provisions expanding state power and undocumented learners. Okay, they speak about the duty on the state regarding positive measures in languages. They mention a few acts as well as the 2 white papers. They quote court rulings and law regarding SGBs being best positioned as parents and guardians to ensure democratic school governance. They quote from the white paper. They speak about the partnership model between SGBs and DBE. They argue unconstitutional infringement of sections 29, 30, and 31, insofar the bill's limitation of these rights. Speaking about language. Okay. They deal with limitation clause in the Constitution. They quote further court cases regarding language. They go into the definition of required documents, imposing of arbitrary requirements with criminal sanction for failure to comply, does not serve legitimate purpose, and fails to consider and resolve practical barriers in obtaining such documents from DHA. They indicate their concern regarding criminal sanctions for non-compliance with compulsory attendance, indicating that it could disproportionately infringe upon those rights quoted. In order to make some proposed amendments, they propose the deletion of the provisions which take away and limit power correctly vested with the SGB and that confers them instead with the state. Decentralizing decision-making power in the provincial departments who are already overburdened and under-resourced and not appropriately placed to make such decisions, such as language policy, admission, staff appointments, and leasing of facilities. They just have a look here. They want a provision by the bill of provincial oversight and consultation with SGB on language and admission, with a final decision lying with the SGB and a reasonable dispute resolution process for parents. They want definitions for equality and equity. I think those are new requests. They want the review of required documents in the definitions. And such documents must serve a legitimate purpose with regards to school administration or admission and are readily available and accessible via the DHA. And they hold that SGBs are most appropriate body dealing with admission and language. And I think that's the end of that document. Okay. So next one, Annexure C, Bailey from AfriForum. Thank you. Okay. First page seems to reference context. Okay, this reads very similar to the previous AfriForum document. I'm not sure if it's maybe a copy and paste by a different person. It reads that way. Let me just see if there's anything different in this document that we haven't read out yet. Now there's the category schools again. Okay, that's also similar context to previous document. Okay. No, this seems like it's just a different person with the same information. Let me just have a look until the end quickly. Yeah, that's the same clauses of 4 that they dealt with. That's the same clause 5 that they dealt with in the previous document. And 7, yes, I remember that one, the exemption. 14 was the procurement, 19 was the dissolution of the SGB. Okay, so this one is the same, so we don't have to go into detail in that one. Then number 4 is Annexure D, Commission for Gender Equality. Okay. Let's have a look here. That's some context. Okay, I think that relates to national parliament proceedings. I'm not too sure. They raise concerns regarding discrimination within education and at schools, specifically based on sexual orientation and gender expression, leading to refusal of admission and even expulsion. They raise concerns regarding violence and harassment and bullying, prejudice and intimidation. They raise concerns regarding rigid uniform policies, absence of protocols for managing learner transitions, inadequate training for educators on LGBTI and gender identity rights, lack of gender-neutral bathrooms and permission for transgender and gender-diverse learners to utilize bathrooms corresponding to gender identity, complexities surrounding changing school records upon transitioning, absence of third gender profiles. Okay. They speak about empowerment and full exercise of the right of basic education. Okay, let's see. They quote some constitutional rights and the Universal Declaration on Human Rights. They speak about the legal responsibilities of the state. Okay. And that the bill remains silent on full realization of this right or rights. They go into more detail on the respective rights. They quote the Constitution. Okay. I think they're quoting the right to equality there. Okay, they focus specifically on the categories of sex and gender in the Constitution. They quote a court case there. Okay. They indicate that there are gaps both in the bill and in SASSA, that they have received complaints and are in active litigation regarding these matters. That the bill and the SASSA doesn't address ongoing bullying and harassment, enforcing strict or unreasonable school dress codes. I think that might relate to school code of conduct policies, okay? Confidential information, access to restrooms, harassment, discriminatory, disciplinary actions. Okay. speak more about discrimination, marginalization. Okay, they're asking for amendments. Let's have a look. They're asking for amendment on that. Let me just have a look here. Is this an inclusion or an amendment? Oh, should incorporate. Okay, so these are new considerations that they want us to consider. Definition for bullying. They propose a definition for gender expression and gender non-conforming. They suggest a definition for non-binary or genderqueer. They propose definition for transition. Okay, let me have a look here. Okay, they propose definition for transgender. They ask that amendment to include a section that deals with bullying, harassment, and discrimination. But it doesn't seem like they've drafted that particular amendment. It might be something for the department to consider. Then they speak about privacy and confidentiality. To my knowledge, Poppy's supposed to deal with this, but the department can answer on this regard here. Whether it is a matter for this bill. Okay. Because to my knowledge, if you're not in compliance with Poppy, it doesn't matter what it is, it's a criminal matter. Then names, pronouns, and school records. They suggest that students have a right to be addressed by a name and pronoun corresponding to their gender identity. Let's have a look here. And they make examples. And request that then documents are appropriately updated. They mentioned there may be some legal obligations in this regard. Access to gender segregated activities and facilities. So I think they're explaining why, because I don't see an amendment here. So that's something for the department to consider. Or the department can give us feedback on this when we get to clause by clause matters. Okay, because there's no proposed amendment in here. Then dress code, I think that relates to code of conduct that SGBs deal with. And their concern is regarding discrimination. Okay. But there's no proposed amendment there, so that is something for the department to also consider and give us feedback on. This is training and professional development. Let's have a look here. This is. Okay, then they suggest what such programs could include. And then they conclude. Okay. So the amendments. Okay. So there's no clear indication whether that was support or object, but they've requested amendments. Colleagues, it's 12:43. Are we happy to break at 1? I just want to check, member Christians, are you unavailable the whole afternoon?
Chair, I'll check now. I'll try to resettle certain things. What are you saying? Are we breaking 1 o'clock and you attempt to get back 2 o'clock?
Yes, I would like to give you all a chance to have lunch, because even if you're sitting at home, I can just imagine it's a bit difficult sitting at your laptop whole morning in order to go through the respective submissions.
Yeah, I'll check. Let's get back at 2 and then we can see. I'll try to reschedule my things. I don't know if I can, but I'll try to.
So are you okay if we reconvene at 2 o'clock then?
Yes, yes.
Okay, cool. Members, I'm going to continue with the next 15 minutes. And then we're going to break at 1 and return at 2. And we don't have that many to conclude still. And hopefully we will then be able to finish up early for everyone. Thank you. We are at Annexure E, Mr. Mackenzie, John Mackenzie. Am I
Chairperson,
right?
just
Am I
before you
wrong?
proceed with that, I don't think you can see that my hand is up, but just before you proceed,
Apologies.
I just heard the exchange between yourself and Member Christians. I doubt whether I will be available at 2 o'clock in view of my respect for having rearranged at my instance the other meeting. So one of two things. I want to now excuse my presence in that meeting at 2 o'clock if we proceed, as opposed to taking the meeting further sometime next week. So that's where I'm just leaving it for the meeting. Thank you.
No problem. I think, members, if possible, that we then excuse Advocate Maasdorp at 2. And if we need legal advice, if, for example, we have contrary amendments that we are proposing, we can always then ask that is then asked for assistance, and that we maybe then almost like sign the report off via email then, once we are happy with what that looks like. Would that be in order with members? And that's, I don't know whether there will be contrary amendments. I'm just making an assumption in case we do need to make amendments. Okay, I don't hear any objections. Okay. Perfect. Advocate Master, we will then excuse you for the when we reconvene at 2. Thank you so much. Okay, we are at Mr. Mackenzie, Annexure E. Okay, this is not addressed to us, this letter. I am not Ms. Kaka or Mr. Nchabaleng. However, we will go through it anyway. It objects to clause 35 and the bill, essentially. It speaks to Mr. John and his wife. Speaks about his daughter. They speak about the curriculum and technology. They highlight the difference between home education and school education, how their time is used, books that are available, subject matters and strengths. They highlight the religious background, alternate important studies, an all-in-one class, tests and examinations, objections to clause 30. Then they copy and paste the clause. Okay. They highlight where they object. Okay. They have concerns regarding the cabinet instructions before the CS was created. They have problems with the CS. They don't believe the bill reflects reality on the ground, that it's impractical. And then they conclude. Okay, so that's an objection. We can then go to, is it Ms. or Mrs., Mr. or Mrs. Correa, Annexure F. Okay, this is Ms. or Mr. Korea, Annexure F. Okay. It objects to the bill, indicates their homeschool. Again, this submission mentions the SIAs. The definition of homeschooling, they object to clause 35. The competent assessor, suitable program. They object to the standard and the comparison to the national standard and the CAPS curriculum. They want to know the criteria the investigation will take. They are concerned about micro schools, that online learning and micro independent schools are provided for, and the provision for regulations on learner pregnancy. Okay, that's the end of the submission. So that's an objection. Then Annexure G, Mr. Rian van die Kerk, I think. Okay, colleagues, we think the name on the document is a submission from one person on someone else's behalf. It's on the letterhead of primary school in Nikubrumer in Beaufort West. I'm not sure what the comments are on the side, but okay. They want to address clauses 4, 5, 16, and 34. That deals with admission, language, central procurement. What was 34 now again? Okay, we'll deal with that now. So it's admissions that they reject. They reject clause 5 regarding language. They reject central procurement in clause 16. They quote a section in SASA already dealing with procurement and indicating the amendments are necessary. They want to be able to opt out. Oh, okay. So clause 34 was the providing of quarterly reports on income and expenditure, indicating administrative burden. They indicate that the annual reports that they submit should be sufficient, and that's the end. Okay, so that's an objection. Then Annexure H, Miss or Mr. Dupriya. Okay, short and sweet. Let's see. Okay. So let me just quickly see here. So Annexure H is actually Van die Kerk, and Dupriya is the previous one. Yes, okay. That's fine. That's fine. We can just deal with the substance quickly. You can swap it around later. As long as we deal with all of the substance, we should be fine. Okay, they reject the bill. Clauses 4, 5, 15, 19, 14, and 39. Okay, no amendments. Cool, thank you. Let's move to Annexure I, Mr. or Ms. Leonard Leroux. Okay, it's the same thing. So it's an objection. We don't have to read it out again. Thanks. Next one is Ms. Swart and Neksha J. Okay. Says for purposes of public comment regarding Bella. Okay. Children have right to participate in lawmaking process. Claims is denied. Then the first paragraph speaks about Gauteng. Quotes a video. I don't recall in the Western Cape us ever denying children. There were multiple children in the public participation process. I'm assuming this is in a different province.
Yeah, it is.
Okay, let me just have a look here. Quotes various different constitutional sections. Speaks about the NCOP and the public legislation, public hearing of Feb. No live streamings or recordings available. That does not relate to the Western Cape. Okay. Then it speaks about Mpumalanga. I don't think this is a Western Cape submission. Okay, so she sends it to everyone at the bottom, but the content is unrelated to the Western Cape. The clauses are related to the bill. So we can consider, well, majority of the subject is copying and pasting the Constitution. So I don't think that's too much of a problem. Members can just reference the Constitution online, or if they have a copy, they can reference it accordingly. But the rest of the items don't seem to be related to the Western Cape. But we'll note the objection. Thank you. Then Ms. De Wet, the chair of the Association for Homeschooling, Annexure K. Okay, I will end off with Annexure K and then we will continue with the next one at 2. Okay, this one is referenced to us. Okay, background of Homeschooling Association. They raised their concerns regarding the constitutionality of the bill. Clause 1, definitions of basic education, home education, and competent assessor, and clause 35 relating to homeschooling. They raise concerns regarding the CS not taking into account existing legislation. That the CS, I think I skipped a paragraph there. The CS does not contain a criminological assessment of the impact of clause 2B. I think that's a new matter for consideration. The bill, when published, was not accompanied by the CS. I think that might have been at the beginning of the bill when the Western Cape asked for the CS. They did eventually send it to us. I'm not sure if they made it public online. Then they argue that clause 35 is not in the best interest of a learner. Sorry, paragraph keeps skipping. But the parent understands home education and accepts responsibility. Okay, so they're quoting there. Sorry, this thing keeps skipping. Okay, then they quote They argue that the clause make it seem as if the judgment of the parent is not to be trusted. And they quote some laws there. Not laws, constitutional sections. They raise concerns regarding officials making decisions parents should be making. They argue that regulation should be less, not more, quote some practices in other countries. Okay, they further quote practices in other countries. They argue that provincial education departments lack capacity to handle a high regulation environment. They reference the Pestalozzi Trust research. They argue that the bill is unwise because it doesn't respect the sanctity of family and parental rights, that it doesn't take into account international trends, and that provincial education departments does not have the capacity to implement the bill. They again raise procedural concerns, and they want amendments regarding parental rights, upholding the sanctity of family life, ensuring well-being and educational rights of children, and then they essentially conclude. My side, 3 minutes on the procedural officer's laptop side. So I'm gonna going through our respective submissions. We ended at annexure K of matrix number 2. So colleagues, I'm going to ask you to just open up your matrix number 2 so that you can see where we are. And then at that, you go to your annexure L of part 2. And we're going to flight that as well. Okay. So we're continuing with the tabling of the annexures. This one, let me just put my glasses back on. Didn't we did Miss de Wet. Yeah. So we at Miss van der Riet now. Let me just have a look here. This one also says they Miss Huda de Wet. Okay, let's just have a look. This is also our medication. Might just be that it's also similar copy paste to some other submissions. Penalty for parents, inappropriate. Registration clause 35, inappropriate. Unrealistic burden, clause 35. Home learning. I think that's, yeah, the curriculum claiming is unconstitutional infringement of rights. Assessment process places undue financial burden on low income and no income families. Powers of minister to make regulations inappropriately broad. No knowledge to make appropriate regulations. Okay, so this one says Huda de Wet. Can we just quickly go back to annexure L so I can just see? It might just be one of those things where multiple people from the same organization submitted the same matter. So that the previous one was K. I think that one was on behalf of the Homeschooling Association, but let's quickly open that one up. Yeah, so that one has the Homeschooling Association's template on. And also, I think, okay, so the first one was on behalf of the whole association, and the second one was a specific separate one from an individual from the organization. Okay, so that's also object then. Then, what is this? This is annexure M. Yes, this is Miss Griffiths, provincial convener of the Women's Alliance for the Citizens of Change. Am I reading that correctly? Okay. There's the introduction. There's values. Oh, this is a scanned in version of a written document we received at one of the public hearings, I think. They complain about corporal punishment not being included and discipline being difficult. She seems to be arguing that I'm unable to really interpret the first sentence, but it more or less seems as if she's arguing that birth control should be more accessible and that family planning has been done away with. I'm struggling to interpret that sentence, but I think that is what it's meant. Okay. Then money. She argues that government wastes too much money and that we should use it to build schools and have buses for schools and invest it in feeding schemes and in school holidays so that kids can go eat at school. To my knowledge, in the Western Cape, children do receive feeding in holidays in the nutrition scheme. I'm not sure how widespread it is, but to my knowledge, there is that. Drugs at school. It asks that we invest monitor systems at schools to check for drugs. Do something for drugs being sold at school. I think she's referring to illegal drugs here. And that gangsters are hanging out at school. Principals are doing nothing to report. Let me have a look here. She wants us to invest money in the walking bus system and more moms to be involved to walk the kids to school and from school. They want schools to pay these people that do that. She says school transport is bad and they're suffering. She advocates for rural and farming areas, especially for long walking in the summer and winter up through rivers. She references Wuppertal and the municipality of Mariatsburg not wanting to build a bridge across the river. She references a young female girl who was subject to rape, was raped on the way to school. She references bus picking up farm kids, but not being able to pick up other children from respective farm, and that the bus passes on the N7. These seem more like service delivery related to education matters, not all falling within the education mandate, but it is so noted. She doesn't want us to close rural schools if scholar transport is a headache. I think that there is a clause regarding schools and mergers. I think that's what she's referring to. She raises concerns regarding teenage pregnancies, prostitutes, drug runners, and users, and says the list is long. She wants us to build more school, especially more no-fee schools. And she says every Friday is 2 Rand Friday. She says stop giving money to schools to renovate buildings at school, rather build new schools. She references a specific school that needs a new class. Some of these issues we can send to WCD directly for service delivery matters. Some of them are unrelated to the bill specifically, but in general, the comments are noted and we can look at what is not included in the bill perhaps. She asks why law enforcement cannot also service rural towns. She claims some schools are being preferred. She asks why police cannot also patrol outside school premises, especially regarding drugs. She rejects the clauses of the bill and she says her community in Ward 7 does so too. Then she speaks about health. To my knowledge, all of this relates to the health department and it's not related to the bill itself, although it is noted. School uniforms, I think that relates to the code of conduct clauses. Apparently, there's some rules regarding types of underwear. And that matters must look ordinary. And apparently this is relating to the fact that there are some behavioral matters that girls have been exuding at this particular school. Okay. Then there's some input regarding young teachers, that retired teachers are coming back. And they have lots of young people sitting at home. Then there are a number of service delivery matters that she lists. While we noted, to my knowledge, these do not fall within our committee mandate or the bill. Then she refers to SASA. And when I say SASA, I don't mean the SASA Act in Education. I mean SASA Social Development. She references foster care and clothing, nutrition, and the monitoring of SASA of these children, drugs, attendance at school. Okay, so there's some matters relating to education regarding the attendance of school. Then she references it's more motivation regarding quality education. Then she seems to motivate the involvement of parents, that children not be running around in the street, and that parents should not be careless. She references some ills in the community regarding gangsterism, drugs, prostitution, kidnapping. She then goes further to reference creche. She considers it a money-making scheme for some people to open a creche as a business. She references, or maybe I think she might be motivating to build a building like a school for creches in the area for teachers and children. She's motivating for the structure of what such a building and education system would look like there. She's giving examples of creches in the area and how much they cost per month. She's referencing the items that children must bring to the creche. She references the transport system there. She references some of the health matters and salaries of teachers. She takes, what's the word? She takes, not note, she raises concern regarding the language policy. It's unclear why she's mentioning that Chinese will be brought in. To my knowledge, Chinese is not an official language in South Africa or an official language in the Western Cape, but there might be schools that have some foreign languages that they offer. So it might be a school that offers a foreign language that she might be referring to. I don't know. Then she references school security, payment of school security, and social workers. I think I'm interpreting that in that manner. And she doesn't want government control over the children's, how parents raising their children. She references the past and history. She references again various social ills. She references the 2 Rand Friday, that children bring money to school and the parents are struggling. I think those are matters that usually go to the SGB. She references that she doesn't know who her SGB members are. She references that some persons on the respective SGBs don't necessarily do what they're supposed to. She references sport. I think this is her motivating for more sport and the impact sport will have on children's lives. She asks why municipalities are not essentially investing more in sports and sport infrastructure, especially for the youth. And she indicates that she rejects the bill, she doesn't support it, she refers to it again in Afrikaans, and then she ends off with a signature. Thank you so much. So that is an objection. Okay. With that, we have concluded the annexures of section of matrix 2. Sorry, I'm getting confused now. We are now going to conclude the annexures on matrix 3. Okay, almost there. Thank you so much. This is Ms. Wigman Heath. And she sent it to us, but she says, Dear Mr. Nchabeleng, which is the NCOP chair, I think. I think she probably just copy and pasted from an NCOP one that she probably sent. She starts with her context. She indicates that she objects to the bill. She references the SIA document that's not been made public. Okay. She references research on home education not being sufficient. She feels the bill is outdated. I think while this has been raised in many submissions, we haven't actually noted the possibility of the matters by this time being outdated. So that might be something for the members to take into consideration. She references online and hybrid learning and independent micro schools. This has also been referred to in many submissions. She references wording of just cause and the best interest of the learner, that she doesn't know what this means. And what does it imply? That it is vague and can be misinterpreted. Then she references the definition of a competent assessor, seeking clarity on the recognized professional body in the field of education. And then she asks some questions such as who will be appointing the competent assessor, the final authority, and whether the home educators will have a choice. She references corporal punishment. She indicates that she doesn't agree with corporal punishment, but no alternative method of discipline has been provided, and that educators need guidance and training for disciplining learners. I think the part of educators needing guidance and training for disciplining learners might be a new matter for DBE to consider. No one has actually asked for an alternative to corporal punishment then. I think this might be the first one. This is, let me have a look here. I think she might be quoting the actual corporate punishment clauses instead. Because, let me just, where's the bill? Just have a look here, because I think she might have accidentally just copy and pasted that clause. Yes, okay. So here where she says CC, she's actually quoting what corporal punishment means, and I think she assumes it is a new clause where you're allowing children to do that, when actually what the original SASA says is you're not allowed people to do that. So she's essentially agreeing that corporal punishment should not be allowed. Okay, and that's based on the current SASA. Then home education. She argues that home education is not school at home. That you can't regulate it in the same way as normal education at a school. That it depends on the child's ability, skills, and interests. She indicates that home education should not only restrict a child to their home, because it's not in their best interest, and it restricts the education of the child. She argues that the parent is responsible for the child's education. And she objects to being restricted to be using to 50% or more of the content and skills of the NSC, which is CAPS. She argues that some people have difficulty obtaining required documents in subsection 1. And that relates to Department of Home Affairs, or DHA. She says that there's a burden on the school when these particular documents are not found. She seems to object to grade R being compulsory, making the argument that if DBE is unable to maintain or upgrade current schools or build new schools, that they will not have funding for grade R. She objects to imprisonment of parents being in the child's best interest for non-compliance. She raises various social ills as a motivation. She indicates that offering a foundation phase is great. So in principle, she doesn't have a problem with it, it seems, but based on finances, she does not believe it can be afforded and therefore not be enforced. She references more social ills in disruption of education. She seems to agree that the right to the child in terms of education not be hindered, interrupted, or disrupted. She highlights some concerns regarding disruption, such as protesting or strikes. She questions some of the reasons. She argues that the education of a child should not be interrupted and that parents must be held accountable. Okay. She argues at monitoring learning attendance that reasonable effort should be clarified. And further investigation by the SGB should also be clarified. She questions how the SGB is supposed to intervene and get a hold of the parents and social development. At clause 4, she deals with unfair discrimination and she requests clarity. She refers to her previous clause where if you don't have the necessary documents, will the school ignore it and admit the learner to avoid unfair discrimination? She argues that if documents are compulsory, if aren't compulsory, how will the clause be enforced? She's arguing there's some contradiction between clauses. Asking questions regarding timelines, compliance of law. She goes further to say that she's unclear as to whether the child must be 4 or 5 years old with admission to grade R. She says that she's confused regarding what the clause really means, if it's optional. Indicating the schools have limited capacity. She's arguing that there's possibility for abuse of the clause. She references overcrowding, infrastructure, lack of educators. She seems to object to, what is this? Clause 4D regarding admission policy and the HOD having the final say. Asking questions on the grounds that they would decline such policy. Knowing the needs of a community, the best interest of a child. She references some factors. She references some amenities children should have access to, such as transport. She speaks about learner ratio educator-learner ratio, sorry. She questions whether DBE will have the time to create reports on available resources for every school. She questions the ability to provide quality and sufficient resources, efficient and effective use of resources. She questions whether any schools really in the country have available space for additional learners. She references infrastructure and overcrowding. She references centralization of decision-making. In 4E, she wants clarification on whether 30 days is business school or calendar days. Again, for E, she's requesting information about the days. She's questioning capacity constraints of the DBE. She questions why every school needs to be consistent with DBE's admission policy, the capacity to deal with day-to-day matters, administrative burden on HODs. She questions timelines. And she wishes the SGB in the school to have final authority on admissions policies. 4G again, questions timelines, resources in the next section, 4G. Okay, language policy. She references means, capacity, and finances, and the centralization of it. Okay, that's similar to centralization. Okay, she references similar arguments from the clause 4 for clause 5. So I'm not going to go through everything. Again, she speaks about centralization and she gives examples. She references sign language. She asks questions regarding practicalities of the particular clause of 5B. She asks about where children will go if there's no special needs school in the area. Then she references the authority of the HOD in the decision-making powers. Again, she references some social ills and capacity constraints. She requests the cost implications to implement this clause. It's a lot of duplication, so I'm just trying to see if there's anything new regarding new classrooms, resources. She questions language policies changing too often. She gives some historical context. She speaks regarding notices and publishing in media outlets. The cost of such notices. She references the Mpumalanga Legislature Facebook page and one newspaper. I suspect this section regarding public participation relates to Mpumalanga. The second section seems to relate to the Eastern Cape. In this section, let me just have a look here. This is also regarding timelines and opportunity, reasonable opportunity and reasonable notice. These are mostly questions. She references public hearings that, to my knowledge, is not in the Western Cape. She speaks about adequate learning material and the financial affordability. She again references centralization of and arguments in previous clauses as well as timelines. In clause 6, she's requesting clarity on a few matters there, including finances. She's questioning whether there was consultation with stakeholders. She's concerned regarding code of conduct. She's making comparisons through using different religions. In clause, what is this? Sorry. Also code of conduct, she's requesting what just cause shown means, what disciplinary proceedings would consist of, what is age appropriate, and in the best interest of learner. Clause 9. She's questioning timelines and the impact of a suspension on a learner, and that such decisions should be made by the SGB and not the HOD. At clause 10 regarding corporal punishment, She argues corporal punishment should be against the law. It is. This is actually a copy and paste of what is currently, I think it's just the last section of or restricting a child's use of the toilet that is being inserted, if I'm not mistaken. So I think she thought at the time of writing this that this is a new clause, but my understanding is this is an amendment of a current clause in the Act. Yes, okay. Then in the merger of schools, she's concerned regarding what will happen to employees of such merged schools. I think that's a new matter that has not been traversed. She's questioning it being whether it's going to be published in more than one newspaper and the notice of such. She questions some costs relating to it and consequences and accountability. At clause 14, she questions the method of central procurement. Okay. She gives examples of what central procurement could mean in terms of implications and references corruption. Okay, at clause 15, disregarding the withdrawal of functions of a SGB, she seems opposed to this and gives some experiences. She questions whether the DBE has qualified persons to perform the withdrawn functions of SGBs. At clause 19, she disagrees with the clause and that SGBs that are not doing their work should be held accountable. And that if they were training for SGBs, there wouldn't be problems. Then, with closure of small schools in clause 25, she disagrees with the clause, with the closure of schools, sorry. But yes, I think she does disagree with the clause. She speaks against about notices. And essentially, when you give notice for such matters, as well as the cost involvements and how widespread it would be. And she references previous experience. She asks what is reasonable. She argues that public hearings in the past have not had proper notice or enough notice. She says Parliament ignored thousands of submissions regarding bail. I suspect, again, this relates either to National Parliament or if she is in a different province. Because if you haven't noticed, I just took you through 5,445 submissions. Then she asked about the method of calculation and the non-viability of a school. She speaks about child ratios to educators and raises her concerns. She raises her concerns regarding multi-grades within home education and that she doesn't think it's an issue, but that the curriculum for these multi-grades might be. And she disagrees that caps would be conducive. Again, she raises concerns regarding the definition of days and matters such as questioning the clause on where appropriate and transport and state resources. She questions the definition of accessible. She goes into the different factors of small schools, affecting small schools as well as state resources. She gives alternatives for the DBE to focus on instead of closing small schools. In clause 27, she questions whether the HOD has the expertise and ability to issue directives. Clause 28, she suggests that these meetings are also be able to held virtually. So at clause 28, I think actually she's asking us for a new amendment there at clause 28. I don't think anyone has asked for virtual meetings to be included in budget meetings. I don't know whether the clause excludes virtual meetings. It might be that schools already allow for virtual meetings. I'm not too sure, but that is something we can put to the DBE. Clause 29. She questions why an SGB has to apply to DBE for approval to pay a state employee, and on what grounds such application would be refused. She raises concern regarding extra burden upon DBE as well as SGB based on the clauses and the finances of a school. She argues that there's a clause addressing the required documentation for exemption of school fees, but that SASSA itself doesn't address it. Let me just see here. She argues that if parents qualify for exemption of school fees, then the DBE needs to cover the costs, which they currently don't, or if they do, the amount is minimal. She's arguing for more no-fee schools. She's arguing that exemptions should be allowed for the amount that the DBE is financially able to supply the school with. In clause 31, she argues for transparent accounting and good governance. She's asking where she can see respective documents and where they can access financial statements. Clause 32. She's arguing that schools shouldn't be expected to increase their workload just because some have irregularities and that it's unfair on other schools. Clause 33. She's arguing that there's an error and that SASSA says 3 months and does not say 6 months. Let's just quickly go to the SASSA. I have one in front of me here. This is. Have a look here. Clause 633 wants to amend 46. And that deals with subsection 1. Now, let me just have a look here. Oh, subsection 4, sorry. She's right. Let me have a look at the bill quickly. I think DBE made a mistake in the drafting of the bill. Let me just have a look here. Clause 33. Just check. Oh, no. Okay. Okay, I get where the mistake comes in. Okay. So in the clause, it does say of 3 taken out, not exceeding 12 months. So okay. So she did put it in there. Maybe she's referring to the presentation. Let me just have a look here. Where does she find the 6 months? Okay, I don't know where she's finding the 6 months. It might just be that another province made a mistake in one of the presentations. But the Act does say 3, and the new clause does take it to 12. So we must just make a note of that when we get to the clause by clause, just to check that everything's in order there. She argues about the independent school registration being complex and expensive. And that imprisonment and fines aren't always the solution. She argues there's not enough research being done on homeschooling. She's making examples and giving experience of what homeschooling looks like. She references various rights of the child, an impact of homeschooling. She goes into the different subsections. She further references red tape. She gives examples. She mentions capacity constraints. She agrees with the Pestalozzi Trust's recommendations. She references some social ills, overcrowding in schools. Okay, if she's referencing the Pestalozzi Trust recommendations, then I can go through this homeschooling actually quite quickly, because then this has already been traversed. Okay. Yeah, these have all been dealt with. Okay, these have all been dealt with via the Pestalozzi Trust recommendations as well. It is so noted. She questions various things on homeschooling assessment. She reiterates her rights as a parent and DBE not having authority over a child. She references again timelines and definition clarity, seeking questions. She questions DBE's ability to investigate and show proof, their expertise, references again the best interest of the child and makes respective motivations. Okay, these are all similar to the Pestalozzi Trust matters then. She disagrees with clause, what is this, 39? Oh no, sorry, this is still 35 regarding home education. Okay. Thirty-six. She questions the criminalization within the clause. She indicates that clause 39 is vague. She says that she disagrees with the departmental policies and that she believes this is what the regulation is referring to, it seems. She is objecting to the bill itself in some of these passages and references various matters regarding abortion. She, have a look here. Okay, so she objected to that clause. She objects to the amendment to the preamble, arguing there's a difference between home education and schools. She references various other matters in the preambles, such as history being included. She questions the, what do you call it, the track record of DBE. She uses the preamble and juxtaposes it against the provisions in the bill to say that it's contradictory. She questions whether the DBE wants what's in the preamble based on the clauses that is put in the bill. And she then, I think, concludes and objects to the bill. Okay, thank you so much. That was a mouthful. Then our next submission, Annexure B, is from referendums.co.za team. Bradley ETC. Okay. Okay. Our next one, Annexure B. Okay. There's a preamble. They speak out against abortion relating to clause 39. They ask for the policy to be amended. I think amendment of policies tend to go to the NCOP and the NA, but we can just check with the DBE. They argue that there should not be centralization. They refer to clauses 4, 5, and 35, sorry. These are admissions, language, and homeschooling, if I remember correctly. They argue against one-size-fits-all curriculum. They argue against comprehensive sexuality education. They make special mention of special needs children. And the curricula should be considerate of various religious values and beliefs. They raise concerns regarding home education. On language, they raise concern and that such should remain with SGBs. With admissions, also raising concerns. and that such should remain with SGBs. Non-viable school closures, they object to it. Grade R, they object to it being compulsory. They also object to the criminalization in the clause. They raise concerns regarding the affordability from parental side for grade R. They reference some information. They reference NA and NCOP procedures. They reference some colleagues or acquaintances and people here. And then they conclude by not supporting the bill. So that's object. Okay. Then Annexure C. That's Mr. Heath, I think. Also, okay, just for the record, I'm not Mr. Chabaleng, but comments relates to clauses 1, 2, 4, 5, 25, 33, 35, and 40. Okay, let's just quickly go through get past some of the context. There is concerns on home education. Also similarly, one size fit all type of situation. There is concerns regarding assessments. Quality of education, infrastructure, various social ills, objecting to closure of schools, especially small schools. They raise concerns that not enough schools are being built. And they argue that the preamble does not reflect what is in the bill. And they object to the bill. Okay. Then Annexure D, Part 3 is, I think, Ms. Creer. Annexure D of Part 3. Oh, yes. I remember reading this actually quite late last night. Okay. National Council for the Blind and Tape Aids for the Blind. I remember this one. Okay. Here's some context. They give a summary of the legislative environment within special education needs. Then at clause 12, they want, okay, so these are new provisions that are being asked for. They want at clause 12 that when a school gets to be designated as a public school with a special focus on talent, that we include specialized disability for learners with special education needs. So essentially, they want to give the provincial minister the extra power as well. Then clause 13, they want the clause 12A amended to also include LSEN and special schools in the merger clause. So essentially, they want the provincial minister to have similar to the other schools that powers relating to special needs. Then at clause 25, relating to the closure of schools, they just want a factor to be included regarding special education needs because they have smaller classrooms. Okay, so those are all things members can consider when it gets to that point. They also highlight omissions in the bill. No provision for learners with special needs regard to textbooks and education literature in accessible formats. provision of monitors during exams and extension of duration to complete papers, provision of assistive devices, orientation and monitoring training, provision for second chance matric opportunities, provision for transport, provision for blended and online learning. So those are all new matters that are being proposed to us. Okay, that is something that the members can also consider. So I'm just going to write that as recommendations for amendment, because it didn't specifically indicate whether it supports or objects. Okay. Then Annexure E is various persons, Miss Parker, a second Miss Parker, Miss Creel, Miss Arendse, and Miss Storm. Okay. This is a submission from Education First Research Group based on independent micro schools. Okay. They reject the bill. They give some background on micro schools. More background on micro schools. Okay, some more context and background. Factors they wish us to take into consideration. They reference some schools that closed down in Gauteng. They argue that the registration of micro schools is very different than larger independent schools and that it's unaffordable. She references some Umalusi fees there and independent school fees. She references some Mpumalanga public hearings. Okay, she references the SIAs and the research that went into the SIAs. Okay, the proposals are that the MECs be able to issue instructions for the registration of independent micro schools. I think this might be a new provision that they're asking. I haven't seen this in some of the matters. I think the matrix spoke generally about micro schools, but no one actually made a concrete proposal. The right to use alternative curricular educational approaches and assessment procedures be protected. Best interests of learners be protected by key principles in the Children's Act and SASA. That the penalty of 12 months be removed from the bill. That unregistered independent institutions are included in dispute resolution procedures. Then they indicate that they have a clause by clause. Here are some practical matters that they would like. Such as exemption of certain fees. Okay, then they go clause by clause. Just going to quickly see if there's anything in the clause by clause that they propose that we haven't mentioned already. Oh, so they're actually proposing a definition for independent micro schools, okay? They're also proposing a inclusion of national curriculum statement grades R to 12. They're asking for an inclusion of definition of school. They're asking for, yeah, these are substantive edits that they're asking for. Okay, let's have a look here. Okay, they're asking essentially for almost like autonomy as independent and independent micro schools. They're asking for an inclusion of definition of school. They're asking for an inclusion of definition of school. Okay, the asking essentially for almost like autonomy as independent and independent micro schools. Okay, the asking essentially for almost like autonomy as independent and independent micro schools. I'm not sure if the DBE has traversed micro schools with us, but that is something that they can advise us on, DBE and WCD, when we get through the amendments. They're asking, essentially what I think they're doing is they're going through the SASA and including micro schools at the respective parts. And for example, here they're including, they want reasonable notices. They want the 12 months to be taken out and it to remain 3 months in the SASA for the criminalization. Okay, these clauses are basically them just including the word "and" or "an independent micro school." They've included some extra factors they would like us to consider. They ask that they are be included in the dispute resolutions. Okay, so these proposals that they're making are based on the above summary that they made. Okay, I think because we haven't traversed that really in previous presentations, that DBE and WCD will just have to indicate their views on those. Then Ms. Furness, Annexure F. Almost there. Okay. Okay, Ms. Furness objects to the bill. She objects to certain documents not being made public. Okay, like the CS and the evidence for homeschooling. She says homeschooling education was not included in some of the consultations. This is very similar comments to some other comments. I'll just quickly go through these. They specifically object to clauses 1, 2, and 35 that most of the homeschooling community seems to object to. They give proposals for alternative education. They quote constitutional preambles and clauses. She references public hearings in Gauteng and Free State and public participation in general. She again mentions Gauteng. They ask if we are satisfied regarding our public participation and references some court cases. She says that media and public should not be excluded. To my knowledge, in the Western Cape, we do not exclude media from the House or committees, but perhaps she might be referring to other public hearings. She asked whether provincial legislatures hired companies to record public hearings. We do. I'm not sure about other public provincial legislatures and so on, but we do record our meetings. To my knowledge, the Western Cape is on YouTube, but I'm not sure about other provinces. I think, so, yes, we're on YouTube and our public hearings are all recorded, yes. Okay. If I'm wrong, the procedural officer will correct me. Then she's asking about public participation regarding advertising, information sessions. Did the Western Cape provide information to interested parties timeously? So we will include that in our negotiating mandate regarding the amount of stakeholders we emailed and the type of steps we took into public participation. She's asking whether the bill was provided to people. By us, we did provide the bill to people. I can't answer why few school governing bodies attended the hearing. It's perhaps some just did not want to, I don't know. How many written or oral submissions were received? well, at this time, we were not able to necessarily answer, but I do think that I gave some regular updates in committee on these numbers, and I'll do so again at the end today. Was it positive or negative? I think by reading out all of the submissions today, we can answer that today. So far, majority overwhelmingly has been negative, I guess. Then she's arguing that public hearings should not be organized during the school day because it excludes stakeholders from meaningful participation. In the Western Cape, we did not organize school hearings during the school day. We actually made a deliberate decision in the Western Cape not to have it during school hours. And then she references Gauteng proceedings. She argues against imprisonment for various reasons. She's concerned about the research on home education and motivates for how home education saves the state money. And she gives examples and figures there. I don't know whether the figures are correct, but perhaps DBE might know. These are all documents she's previously quoted, and she concludes by not supporting the bill. Okay. Then Niksha G is Tim and Christy Robson. Okay. Sure. Okay. It looks a lot, but it's actually only 8 pages. Okay. Introduction. Okay, then they give a history of the bill. It highlights concerns regarding homeschooling, cottage schools, costs of the bill, that they will become more expensive, financial viability and quality of public schools, concerns regarding the language policies, okay, let's have a look here. Concern regarding religious freedom, on leases, concerns regarding Section 39, concerns regarding school governing bodies have less power, concerns regarding salaries of teachers if SGBs lose control of admissions and less income. She gives a history of home education and it having been criminalized during apartheid, apparently. She objects to the criminalization in the clauses. She speaks about cottage schools and that the bill doesn't make provision for them. She raises concerns regarding the closure of schools clause. She raises concerns regarding administrative load in the registration of independent schools. She raises, let me see here. She raises concerns regarding clauses relating to alcohol. She raises concerns regarding clause 39, regarding learner pregnancy. She raises some technical matters. She quotes some constitutional matters. And then she concludes. Okay, so that's an objection. Then annexure H. Didn't we do Van die Kerk already? Perhaps it's a duplication. It looks like a duplication. I know the surname. Just have a look here. Yes, this is a duplication. I just want to make sure that there's nothing in addition that's in here that hasn't been traversed yet. I definitely read the surname already. Yeah, there's nothing new in this one. Okay, so that's also objection. Then annexure I, Herzog Larum. I think it's Mr. Larum. Okay, so he starts with objecting to the bill, giving a general summary of various clauses he objects to. He raises concerns regarding funding, regarding SGB powers being taken away in clauses. He reiterates the role of parents and their responsibilities and concludes. Okay, so that's an objection. Then annexure J. Did we not have a Wigman earlier? For some reason, I think we had a Wigman earlier as well. Yeah, we had a Wigman earlier, but let's open that to see if it's a different Wigman, perhaps. Just have a look here. Okay, corporate punishment. I remember reading this about alternative methods of discipline. I remember reading about them asking about the role of Department of Home Affairs. All of these grade R arguments have already been made. Imprisonment has been made. I remember the disruption of education matters, monitoring learner attendance, admission policies, rural schools, language policy, funding, withdrawal of SGB functions and dissolution of SGB. Let's have a look here. Rural schools, transport, exemption of, I remember the exemption of school fees, financial statements, quarterly reports, independent schools, home education, management of learner pregnancies. Yes, it's same. It's just there's a little bit of difference in formatting and stuff, but it's the same and objection. Okay. Annexure K, Mr. Christopher Cordero. We had another Cordero earlier as well. Oh, sorry, that was Correa. Okay. Okay, this is from the Learn Free organization. That's introduction. Introduction. Objection to the bill. They say there's no mention of provincial homeschooling regulations. That would be because this is not a provincial bill, but WCED can answer for themselves. References KZN and Northwest. 'Cause So he's arguing that there may be contradiction between if there's a national policy on home education and if it ignores provincial regulations. And that this is not mentioned in the CS. He's indicating the impact of interim homeschooling. I think I'm misinterpreting that. Oh, that's because of overcrowding, sorry. He's asking about child youth care centers and that it's not addressed. He's arguing that it's illegal for provincial education districts to perform a monitoring role, and that's in conflict with the role of Umalusi. And they support the submission of the Pestalozzi Trust. They want ECD included in the bill and references some research. They want maintaining of curriculum and religious freedom. They want recognizing the value of the private sector in the ECD. There is concerns regarding state intervention. They wish for ECD to be regulated. They have concerns regarding practical matters and recommend that we include a section covering ECD, that mandate provinces to set out realistic registration requirements for ECD, that we protect freedom of thought, conscience, and religion regarding curricula and programs in ECD, and delay extending the compulsory schooling age, and rather have a specific ECD bill. And then they conclude, they conclude on the ECD stuff. They raise concerns regarding registration of independent micro schools. They want a regulatory framework for online schooling. They give some background and quote some sections. Okay. Quoting framework and policy and impact in the sector regarding online schooling and micro schools. Okay, and they ask that we propose that online and hybrid education be included in the bill and to reject the bill if it doesn't cover it. They ask for consultation as the homeschooling sector. Yeah, they've already mentioned the ECD and the dialogue. And then they conclude. Thank you so much. Last but not least, Miss Chanel, Aniksha K. L. Oh, sorry, Aniksha L. Just have a look. Maybe it's also accidentally called Aniksha K. It might be not that, one of these. Okay, this formatting looks very suspiciously similar to previous submissions, but let's have a look. Okay, yeah, it is. Okay. Procedural flaws, sayas. Okay, we've seen this already. No medication, compulsory attendance, rejection. We saw this in that long submission where she also indicated, please change the age. Infrastructure concerns. Remove clause 4D and E from bill. Remove clause 5C. So those relate to admission and language. Objection to clause 6 regarding unelected agencies. Okay. Religious freedom. Procurement should include consultation of the school community, religious leaders, and parents. Clause 15, not to hand over SGB functions to the state. Closure of public schools. Removing clause 25. I don't actually think the clause says remove like closure of schools. I think the clause actually speaks to the factors that must be taken into account when closing schools. But we'll have a look as members later. Then registration of independent schools, recommendations regarding micro schools. These have already been traversed in previous proposals. Section 35. Okay, these are all similar that we've already heard and read. In terms of homeschooling and adequate research, they want the whole clause 35 to be removed. Then 36, criminalization of citizens, opposed. Clause 37, they want voluntary court and next mediation when it comes to disputes. 38, provision must be made for the state to be held accountable for damages caused by their agents. Okay. 39, concerns regarding the clause being vague and objecting to it. And then concluding remarks. Perfect. Okay, colleagues, that is the very last submission of the 5,445 submissions that the Western Cape has received, and which I'm reliably informed that we've gone through well as per clauses and paragraphs in the Mohale judgment. Okay. We're going to take a 5-minute break, mostly because I just need to stand up and stretch a little bit, if you don't mind. And then we will start with the clause by clause. Colleagues, if you only support or object to a bill, not to a bill, to a clause, please say so, then we don't have to go through a full negotiation necessarily on a clause. We can then just indicate the particular vote on a particular clause when we come back. If there are amendments, please indicate so that we can then see whether we need to negotiate on amendments or whether we agree on particular amendments. During this process, we will also allow the WCED to put forward whether they agree or disagree, because they've also put forward their respective clauses, and I did indicate that we will deal with their clauses at the same time that we do the clause by clause. I'm also asking members just to keep the homeschooling one open that I said earlier from the presentation, because that is the only one, to my knowledge, that we haven't concluded. But if you then agree with something, then you can pull from your respective documentation what you want to recommend, because there are various recommendations in the submissions, and some of them are contradictory, and some of them not the same, or some of them are similar but different wording. So you can also have a look whether you agree with a particular stakeholder or whether you want to propose your own particular resolution. Thank you so much, Advocate Coleridge-Zills, and I think it's Ms. Malinga. They have other commitments at 3. You are excused. Thank you so much. I'm not sure if anyone else from the WCDED is online still with us. Just want to check quickly. Okay, what I'm going to do is we are taking this 5-minute break. And then we can also just check in the meantime during that time. Thank you, colleagues. We are suspending until 15:35. Oh, sorry, they can't hear me. Sorry, I thought you were able to hear me. I'm just quickly checking that everyone's back online with us before we continue with the clause by clause. Member Harris, are you online still?
Yes, I am still online,
Thank
Chairperson.
you. Thank you so much. Member Christians? Okay, Member Christians might still be coming back from his comfort break. Member Poole?
Yes, Chairperson.
Thank you so much. And I know that Member Fry is with me here in person in the chamber. So we do still have quorum. But colleagues, we are now going to start with the clause by clause.
Chair, I'm present, eh?
Wonderful. Thank you so much. Member Harris, I just want to check just for the procedural officer's records that you're standing in for Member Syed on the clause by clause.
Yes, I'm standing in, and you would obviously join when you can as well.
Okay, no problem. We're just checking for the voting record on the respective clauses. Okay.
Yes.
Let me just perfect. Thank you so much. Okay. Colleagues, you have all previously received a hard copy of the bill. Okay. We are now going, and I'm going to table the respective clauses. If you want an amendment, please raise your hand or indicate through the purple bubbles that you would like to propose amendments, okay? Then what I'll do is please also keep the WCED submission open in front of you because I did indicate that we're going to look at their proposals at the same time that we deal with the clause by clause. And if you can also just keep open the other submissions that related to amendments specifically, such as homeschooling, de Klerk, the AfriForum, Solidariteit, there was CGE, there was various parents that made amendments, there was Learn Free, there was lots of people. Okay, so just keep it open if you want to make reference to respective amendments. Okay, I am now tabling clause 1 of the bill. Clause 1 deals with various definitions. Are there any members that want to make input on clause 1? Member Fry, I just want to quickly see if there are any other hands online. And then Member Christians. Those are the only 2 hands I see so far. So Member Fry and Member Christians in that order. Thank you.
Okay, that's better. Chair, I move to support with amendments for the clause 1, amending additional inclusions such as online schooling, meetings, and special needs education, including the definition of bullying and equality and equity. That's my submission for clause 1. Thank you.
Okay, I just want to quickly check. The online schooling, is that a general request for inclusion?
Yes, Chair.
Okay, and the equality and equity, I remember the de Klerk Foundation also made such a recommendation. Is it similar to that one?
Yes, Chair.
Okay, I will then put it to the WCED as well as to their views, as well as DBE once we get all of the hands. Member Christians?
Chair, just an amendment that corporate punishment must be included. Not
Okay.
the definition that they have, corporal punishment as in corporal punishment in schools.
So you want corporal punishment to be taken out
That's correct.
of the clause? Okay, let me just write here questions. I just want to check if there are any other hands before I hand over to DBE and WCED for their comments before we put the views on this. There was a definition of bullying that CGE recommended that I think that can be considered from their submission. It was a general definition. The other clauses from CGE, I had a look at that, and to my understanding, majority of those are discrimination type of clauses that are already contained in other legislation as well as the Constitution. And I'm always very skeptical about duplication of similar matters across legislation, but I just want to find out what the WCD and DBE advises on that, but particularly whether it is necessary to include the definition for bullying. And then it's not in my notes, my personal notes, but I know that some other stakeholders have requested inclusion of the definition for microschooling. If we can maybe just have the view on that particularly, please, before we continue. Thank you. I'll hand over to the DBE first and then WCED, because I don't think WCED specifically has amendments to that particular clause. DBE? Can I just check from DBE who's online?
Good afternoon, Chair. We're trying to bring Mr. Lucas and Mr. Ndlebe in the meeting. I saw at one point that they were struggling. Just indulgence as we try to bring them back into the meeting. Thank you very much.
Okay, no problem. Then, colleagues, what I'm going to do is I'm going to come back to clause 1, because there are various things we first need to know about clause 1 before I put the vote on clause 1. Clause 2, can I hear members' views on clause 2? Yeah, I see a hand here by me, Member Fry. I don't see any hands online, so Member Fry, you can go so long.
Okay, Chair. I support the intention of making grade R mandatory, but the financial costs and practicality of this decision is just unattainable. Is there a possibility of possibly phasing in grade R? And what about schools that don't have adequate facilities for the implementation of the provisions? And what is the length of time to build capacity in these schools? The prison penalty of 12 months of failure to enroll a child without just cause is very, very worrying for me. And what recourse is available to parents who choose not to send their children to grade R? A possible alternative for clause not exceeding 12 months up to judges be fair is a possible alternative is to stick to 6 months in the current act and supports 4/C remaining the same, that is the disruption of schools and the right to education, because education is a realizable right. Basic education is a realizable right, but we have to be prudent with the way that we implement that realizable right. Thank you, Chair.
Okay, so indicating immediately realizable, right? The sticking to the current SASA in terms of criminalization and not changing it. You suggested supporting 4C regarding disruption of schools, questions regarding finances, even though you supported in principle. Okay, cool. Member Christians?
Thank you, Chair. Just a couple of things. I'm just looking at the presentations also. We said that ECD is a foundation for lifelong learning, and that should also be looked at. So the ECDs should be looked at to help our communities. Secondly, also, I want to agree, we all said that money is a problem, and there's a lot of financial reasons why we cannot push for grade R, but because of the no financial resources for that. And then just lastly, what Member Fry said is I especially feel saddened for those poor communities, and I think it's too harsh to criminalize parents for not. They said there should be another measure. I don't know now, but there should be another measure, and not criminalize parents for not putting their children in school. So I don't know exactly the amendment there, but I don't think it's fair on the poor of the poorest of the poor when you criminalize or even impose a fine. Thank you, Chair.
Thank you so much. I just want to check if I see any other hands. Member Poole?
Thank you, Chair. I concur with Member Fry, and I second him on his opposement. But I remember the Clare Foundation made mention of it in 13 and 14, and maybe it also have to be included as amendment. Thank you, Chair.
Are you talking about the undocumented learners that they were referring to?
Yes.
Okay, cool. So for those who forgot, the Evia de Klerk Foundation in this particular clause indicated that provision should be made for undocumented learners, because if you're undocumented and you're not getting your documentation, then the required documentation that you need, you're not going to have it. So essentially, you'll be criminalizing families for something that they're not necessarily responsible for. Okay. Okay, let me just have a look here. I have similar comments regarding finances. While in principle, I support grade R, and similarly, the same principle would apply to ECD, for example. However, based on the calculations, and I would like us to include in the negotiating mandate under this clause the presentations of the FFC, the DBE, and National Treasury on the finances and costing and funding. Basic education is an immediately realizable right. That means it's not the same as other topics where other topics are important, and I'm going to use tourism for example now. It's very important. But tourism isn't necessarily an immediately realizable right. So if you have legislation that is not fully funded and the law becomes law today, it is an immediately realizable right that someone can take you to court for not making full provision for. So the fact that there has been admission that there's no budget for the Bella bill, there's been no committed funding for the Bella bill, and there's no money. So there is no money for Bella. If you take the 17.7 billion rand and conservatively divide it by 9 provinces, you get to 2 billion. That does not take into consideration that the 17.7 billion is based on a formula of 1 to 40 learners, as well as there are multiple uncosted matters that is in the previous presentations that I would like a summary to be included in this particular clause. And then perhaps our procedural officer can use her nice English to put the summary of the previous meetings on those presentations in this clause. But my proposal would be that we thus oppose this clause with the respective recommendations that the current criminalization proposal not be supported, that we stick to the current SASA, that we agree to the clause 4C that speaks to the implications of disruption of a school, and that we ask the DBE about the provisions that can be made for undocumented learners, so that they are not criminalized for something they're not responsible for. I just want to find out, are there any other views on clause 2? Member Fry, Member Christians, I'm not sure if that's a new hand or an old hand.
Old hand, Chair, I'll take it down.
No problem, Member Fry.
It's just to add to that, in yesterday's meeting, it was noted that the billable will be 70%, is already 70% funded. That I don't believe is correct, because the 70% of the is for the full budget of the Department of Education, not just for the billable. Thank you.
Okay, we can always in our summary include provincial budget figures in our summary under clause 2. Member Christians, I just want to check whether you opposed or supported the clause just before I put the vote on it.
No, so with the amendments, Chair, I support it with the amendments that
So
we
you
made.
support with amendments. Okay, Member Poole. Member Poole, can you hear me? I think he did say oppose earlier. I just want to check.
Yeah, I did.
Member Poole, can you hear me? Okay, I'll continue so long. Member Harris.
Chairperson, thank you. As the ANC, we support the bill as it is currently and those clauses as it stands, without any form of amendments that was received. Thank you, Comrade Chair.
Okay, so for every clause you support without amendments.
The current clauses as it's reflected in the billable, yes.
Okay, I'll note it like that so that I don't have to ask you each time.
Yes, yes.
No problem. Member Poole?
Yes, Madam Chair, I second Member Fry proposal. So yes, yep.
Chair, my hand is up.
No problem, Member Christians.
I don't know if I said it correctly. Let me just get it back. You know, the grade R, we said we don't have the money for it and all of that. So it means that I'm then opposing that. But because we don't have the money, that is what I said. But I think I misunderstood you.
No problem. So the amendments that were proposed, some are comments and some are amendments. So the comments that we've asked to be included are regarding the support in principle, that there's no money, and that those presentation summaries that we did get included. It was proposed amendment that the criminalization of parents in, where's the section now? Let me just open it up. The criminalization of parents not sending their children to school be excluded. That's 2, amending section 3 of SASSA, B, A, and B. Okay, so that's on page 6 of the bill. Okay, that's to keep it the same as the current SASSA, not to change it. Then C is the supporting of people not disrupting school. So that's not an amendment, that is support of C. Let me just have a look here. Yes, that's support of C that was proposed. Then you asked that we ask the DBE to look at inclusion of ECD in terms of regulation. And let me just have a look here. And Member Poole asked that we include that the DBE must look at provision for undocumented learners so that their parents aren't criminalized for something that is not their fault. Because if you don't have the respective documents and you have to get it from the Department of Home Affairs, how are you going to get accepted if you need the requirement documents to go to school? So those are the amendments and the comments.
Oh.
Then the question is, if the NCOP does not accept our amendments, would you support the clause?
Yeah, I would not. So, Chair, I would not support the clause if they don't accept our amendments.
Okay, so that would be oppose with amendments then.
Yes.
Am I correct?
Correct.
Okay. And then just for the record, I also object with amendments. I agree with what was proposed, both in comments and amendments. And if the NCOP does not accept it, I would oppose. So I would be oppose with amendments. Thank you so much. Okay, so clause 2 is complete. Okay, clause 3. I just want to quickly check, is the DBE online? Because we do need, I just want to conclude, see if I can conclude clause 1 before I move on.
No, we don't have Mr. Lucas or Mr. Ndlebe as yet.
Okay, we'll wait. We'll come back to clause 1 then. Clause 3, members. So clause 3 is on page 7 of the bill. Let me just have a look here. Okay, it is for the insertion of a clause of 4A. So it's a new clause regarding monitoring learner attendance. Okay, colleagues, member Poole.
Thank you, Chair. Chair, support with amendments. The principal, I believe, upon receiving a report from the educator that the learner is absent, without valid reason, must within 24 hours investigate the matter by making reasonable effort to contact the parents to ascertain the reason as to why the learner is not present at school. Furthermore, the principal has the responsibility to report the matter to the SGB for further intervention. Thank you, Chair.
Thank you so much. I think that's the clause that you've read, which is fine. That's support. Okay. Then any other members? Clause 3
Chair, I second Member Poole's submission.
for the support of the clause. Okay. Any other members?
I'm fine, Chair, with that. I'm also fine with that.
Okay, I'm also in support. And Member Harris has already indicated that the ANC supports all of the clauses. So that is all members support. No amendments to clause 3 then. Okay, because that was reading out of the clause. That's fine. Cool. Clause 4. Clause 4 is an amendment of section 5 of SASSA. I can start if I must. Member Fry.
Chair, I'd like to oppose the clause with amendments that clause 4D be withdrawn, clause 4 subsection E be withdrawn, and clause 4 subsection G to be amended to include if schools fail or refuse to provide the MEC with requested documentation within 7 working days, an appeal may be decided on available evidence. Thank you.
Okay, any other members?
Chair, I would support that.
Sorry, Chair. I forgot to say that I recommend that the clause be withdrawn or struck. With the excuse me, and my suggestion is an alternative. I just want to make that clear.
Okay, so the respective suggestions are in the alternative if the clause is not struck.
Yeah.
Okay, so the recommendation is that clause 4 in its entirety be struck, and there are certain suggestions that are made for alternative amendments. Let me just quickly check. Member Christians was second.
Yeah, no, Chair, I would go with that. The changes proposed, I think that's reasonable. But also, I'll also agree with Member Fry, if it's not changed, that it be struck.
Okay. Member Poole.
I'm in agreement with Member Fry, Chair.
Thank you so much. I just want to add that where you read at line, let me just have a look here, line 43. So clause 4, amending section 5, D, 55D of SASSA, okay? Sorry, I just need to make sure I'm getting all my numbers correctly. Clause 4 of the bill, amending section 55D of SASSA, that instead of after consultation with the governing body of the school, that it reads in consultation with the governing body of the school. So that would be line 8 and 9 of page 8. And I'm in agreement that in the alternative, if the full clause is not struck, that 4D, 4E must be withdrawn. 4G, that it must be amended to include if schools fail or refuse to provide the MEC with requested documentation within 7 working days, so that appeal may be decided on the available evidence, and that there must be an inclusion of an appeal process. But those are part of, in addition to Member Fry's proposals in the alternative, that if the clause is not struck, because I oppose this clause with the respective alternative amendments. Okay. And then Member Harris has already indicated her support. So let's just indicate that. You got all of it, the amendments? We can also just ask the members just to send through what they've already suggested to make sure. Okay, so that was oppose with amendments. And Member Harris indicated support. And I'm just going to write here, members. I've written it down so I can also just forward it to you. Members Bartman can forward. Okay, clause 5. Mr. Ndlebo, are you online with us?
Yes, I am, Chairperson. Thank you.
Thank you so much. We are already at clause 5, but we didn't do clause 1 because we still first needed input on clause 1 before those amendments are put. So can I quickly just summarize what the members have asked? Okay, so on clause 1, Member Fry asked if we could include online schooling and home education into the definitions, as well as per the FV de Klerk Foundation submission, they made a definition proposal on equality and equity. So he moved that we propose that definition. Then Member Christians asked about corporal punishment being removed. I'm not sure whether that's possible because there's constitutional court judgments on that, but you need to advise on that. I asked whether definitions on microschooling could be included because that is something that came through from the stakeholders. And I also asked whether a definition on bullying could be included as per the CGE submission. And we first wanted to hear your input on those before we put the clause and the respective amendments to a vote.
So thank you, Chairperson. Yeah, I think the definition of bullying can be included because it is part of the code of conduct. Corporal punishment cannot be removed. It's a constitutional mandate. I think you might have been following up events on teachers that were found guilty on corporal punishment, and SACE was in trouble for having given lenient sentences around that. So the courts are taking corporal punishment very seriously. The constitutional matter. The definition on cottage school, we didn't include it because when you get inside the bill itself, there's no reference. So you define things on chapter 1 that you're going to refer to in the body. So those cottage schools are not covered at all. And there is this thing that the Bella Bill's focus. It's really on ordinary public schools more than any other thing. Other things are just mentioned there. So when you bring cottage schools, you bring online schools and all that, these are still issues that are being worked on, which are going to be covered in other legislations and guidelines and regulations that are coming. So the focus really on the Bella Bill is on ordinary public schools. Those things of online schooling, they are busy consulting the relevant organizations. The organizations that is bringing cottage school in line, we have advised them to start working with us and the home scholars team in order to bring that as an aspect of homeschooling as well, with a different focus. So those discussions, I think there are dates that have already been made to deal with it. So now that we don't have anything on cottage school inside the body of the Bella Bill, if we define it there, then we must go to town about it. But those consultations with relevant stakeholders hasn't taken place, so we may not define it there. But there are processes to work with the cottage schools and the home scholars and those who deal with online schooling to really focus on those factors and let the Bella Bill for now focus on ordinary public schools, Chairperson.
Okay, so on the online and homeschooling, you're saying that consultations are taking place, but it's not going to be in this bill. But we could,
Yes.
for example, suggest that it be regulated.
Yes, definitely. When you look at homeschooling, the last clause says the minister must regulate on homeschooling. So what we're suggesting we should do, that section where it says the minister must regulate on learner pregnancy, is not only learner pregnancy there. There's a lot of regulations that come in there, including districts, including staffing, including all those things. So we want to take that phrase of homeschooling for regulations and put it there under the list of regulations to be determined. And Chairperson, you'll remember that if regulations are going to be determined, it is compulsory for the department to work with stakeholders to come up with those regulations. So what we suggest we can do is to add cottage schools under the regulations to be determined as well. So you've got a whole list of regulations that we have to work on.
Okay, Mr. Ndlebe, I just want to know whether we can recommend online schooling and home education for regulating, not necessarily for regulations, because whether or not we are willing to give you regulation power is in and of itself a different question. So that is not the question before us right now. The second one, but thank you, we have the answer on that. The second one, you have answered Member Christians, but he's happy to move or not move the matter anyway. Then you've answered me on the microschooling one, so I'm happy not to include it right now. But personally, I don't agree that that must be in a regulation, but I'm happy if to comment that it should be regulated.
Yes.
Then I'm happy to propose that we take the bullying definition of CGE to propose that. I don't see any controversy on the bullying what do you call it, amendment that they proposed, and we will put it into the document then. Then Member Fry also proposed that from the Evia de Klerk Foundation that we propose the equity and equality clauses. I'm going to just take Member Christian's hand. He can indicate himself whether he still wishes for that to be moved or not. I'm not going to speak on his behalf. And then Mr. Ndlebe, if you can just answer us on Member Fry's one as well, please. The equity and equality one. Thanks.
I didn't get the real question around it.
So there's a clause, an amendment that was proposed by the Evia de Klerk Foundation. It's in the matrix documents that was sent to everyone. So it is they have proposed, let me just try and open it quickly. Sorry, let me just open it quickly. So they have moved a proposal for that there must be definitions for equality and equity included in the bill to make distinction between what it means.
Okay.
Okay. Member Christians?
Chair, I don't know. I'm just raising this. Just to come back to that definition is extremely broad. I mean, it seems to me that an educator can be, found guilty for the silliest thing. And as the advocate that accompanied us on the public participation said, even if you tell a child to go clean a classroom for punishment, it's also corporal punishment. So that is extremely broad. I'm not happy with that. I know we must be in line with laws, but that corporal punishment, I don't know if everybody agrees that we go along with such a broad definition. You can actually find educator guilty on almost anything when it falls under corporal punishment. So I just want to say that. Thank you.
Okay, I'm not sure if I'm reading the same corporal punishment definition, but based on what I'm reading, I'm happy to stick to the Constitutional Court outcomes on this particular matter. I just want to check with other members, just so that we can find consensus, or if we have to take it to a vote. Members, what are your views?
I think we covered with that definition of corporal punishment.
No, Mr. Ndlebe.
Oh, sorry.
Mr. Ndlebe, there are 5 members with voting rights on this committee. I need to ask the members with voting rights whether or not they support the matter that was moved by member Christians. As DBE, we obviously always appreciate your input and your guidance, but the members must vote.
Yeah.
Thank you. Member Fry?
The corporal punishment bit. Yes, I support what member Christians was saying. No, sorry. I support what I said about just the information. I'm just getting a bit confused here.
Colleagues, okay, let me remind you. There is under section 1 clause 1.
Yes.
Wanting to amend section 1, subsection C, on page 4 of the bill, a definition of corporal punishment, which is already in SASSA. The amendment that the department wants is the last line saying, or restricting a child's use of the toilet. That is the amendment the department is bringing. The rest is already in SASSA. So member Christians is proposing that the whole section in SASSA, including the amendment in the bill, gets removed. Mr. Ndlebe has advised that the current section is in line with judgments of the Constitutional Court, and because there are different views on the matter, I am putting it to the respective members. So Member Fry, are you with me?
Thank you, I'm with you now. I don't support member Christians.
Okay, thank you. Member Poole?
I don't support member Christians.
Okay, Member Harris has already indicated previously that she supports clause 1 without amendments. And I just want to put it that I'm happy to stick to the parameters of the Constitutional Court judgments on this matter. Okay, now I just want to check quickly. The other amendments, I'm happy to take out my proposal of the microschooling definition, given that it will be regulated in the future. But I would then like to maybe have us comment that the microschooling stakeholders have asked that it also be regulated and that be looked at by DBE, and that we then also ask that online schooling please be looked at and regulated. That's different to regulations, please. Okay, that it be regulated. Then Mr. Ndlebe indicated that they can look at the Evie de Klerk Foundation clause on that for the definitions for equality and equity must be included, and the bullying clause from CGE. Now, I just want to check with members, are you happy with us proposing that those clauses from the stakeholders be included or not?
I'm happy that they've been included.
Okay, thank you, Member Fry. Online?
I also agree, Chair.
Okay, thank you, Member Christians.
I'm in support, Chair.
Okay, thank you. I'm also in support. I'm assuming in this regard, Member Harris is objecting because she supports the clause without amendments. Okay, so let me just highlight. So we're going to include the definition from Evie de Klerk, equality and equity, and the bullying from CGE. We're going to exclude microschooling for the previous reasons mentioned, but we will include it as a comment for future. Then we said we're happy with the corporal punishment, but Member Christians raised is thus in objection. There we go. Then the online schooling we will raise as a comment, we said, because there's current consultations with stakeholders, but we will put it that it must be regulated. Okay. Now, with the amendments that were proposed, colleagues, do we support or oppose clause 1?
With the amendments, I support clause 1.
Okay, thank you, Member Fry. Online?
I'm in support, Chairperson.
Thank you, Member Poole. Member Christians?
Chair, as I indicated, I support everything except the corporal punishment part, but
So are you opposing with amendment?
yes.
Okay, so let me just write here, Christians oppose with amendment, and then just for the record, I'm supporting with the proposed amendments. Okay. Now, clause 1 is done. Colleagues, okay, let's try and get done before 5. Clause 5, because we finished clause 4 already. Let me just get to clause 5. Okay, where's my notes? Okay, colleagues, your views on clause 5? Member Fry?
Chair, I recommend that this clause be withdrawn or struck because the concept of the concept of community is too vague. It has to be clarified. And an alternative clause would be subsection 6.6, section 6, subsection 2 of the South African Schools Act, which says the governing body of a public school may determine the language policy of the school subject to the Constitution. This act and any applicable provincial law, provided that the language policy of a public school must be limited to one or more of the official languages of the Republic as provided in section 6, subsection 1 of the Constitution. And the inclusion of an appeals clause, which says if a parent of a learner is not satisfied with the language policy of the school governing body based on the Constitution, this act and any applicable law they may appeal against the decision to the HOD and or the MEC.
Okay, so to summarize, you want the clause struck as the main proposal, and in
Yes.
the alternative, you want 3 things. Different clarification of community.
Yes.
You want the current SASA to stand with
Yes.
expansion on language ability
Yes.
and an appeals clause.
Yes.
Okay. And I'm with you. Okay, Member Christians?
Chair, Member Fry did a good job there. Yeah, I just want to support that, especially when it comes to the language policy and the appeal authority. So yes, I support that. Thank you.
Thank you. Member Poole?
Support, Member Fry, totally.
And just for the record, I support that we ask for clarification on community, but in the winning answer would be that the entire clause be struck. On the alternative, we need community to be expanded on. I agree with language expansion in the current SASA. and I agree with appeals process in that regard. And then we can just, so it's everyone is oppose with alternative amendments. And that is the same for clause 4 and 5, because the members asked for that to be struck. And then we had Member Harris support. Okay. Clause 6. Let's have a look here. Okay, members, clause 6. That relates to the amendment of section 6A of SASSA. Can I have your views? Member Fry?
Yes.
Chair,
Okay, thank you. Member Poole?
yeah, and support, Chair.
Thank you so much. I'm always happy when everyone's so eager to answer me. Member Christians?
Unfortunately, Chair, I don't support.
Okay, no problem. Is there anything that you want amended, or are you just not supporting?
No, I'm not supporting. I believe it must be struck.
Okay, so let me just write this down. Fry, support. Poole, support. Harris, support. Christians oppose. And just for the record, I support clause 6. Let me just have a look here. My personal reasons for supporting clause 6 is because it speaks about may and not must. So there's no compulsory matters in it. But thank you so much. The vote on clause 6 is done. Clause 7. Member Fry?
Chair, on clause 7, just cause is a bit wide for me, and it can be abused to have frivolous applications for an exemption. So therefore, I would amend the clause that just cause should be replaced with religious, cultural, or medical grounds, in order for the proposed amendment to serve its intended purpose, so that we be clear on what just cause actually means. Thank you.
Okay, thank you so much. Members online?
Support, Chair. I support
And
that.
support that.
Okay, I just want to add that if our what do they call it? If our amendment is not accepted, that we ask that we oppose the clause. Is members in accordance with that?
In accordance, Chair.
Yes,
Yes,
Chair.
Chair.
Okay, so oppose with amendment times 4. It's easier for me to write that way. And then Harris support. Let me just write. Okay, that's clause 7. Then clause 8. Let's have a look at clause 8 quickly. This amends section 8A of SASSA. Okay, let me just have a look here. And the amendment. Okay. Oh, that was regarding taking out the word illegal in the respective areas. Okay. Members, your view on this?
Chair, in support with amendments, retain wording illegal drug in proposed section 81A and inclusion of definition of illegal drug in S1 in the WPSEA, any drug defined in Drugs and Drugs Trafficking Act 1992, Act 140 of 1992, because that is used in contravention of Section 4 of the Act. Thank you, Chair.
Okay, so it's actually in opposing then with amendments if you want to keep the illegal drug section then. So if you want us,
Yes,
okay,
Chair.
so once we then, okay, we'll reference that act, okay? Okay, I understand now. Okay, cool. The members?
I concur with Member Poole, Chair.
Okay, so you want illegal to remain in the act?
Yeah.
Okay, cool. Members Christian?
Agree, Chair, with that?
You want the word illegal and kept?
Yes.
Okay. I also want the word illegal kept, similar to Member Poole, that the definition in the Drugs and Drug Trafficking Act be used, to my knowledge, is the same definition that we use in the province as well. Members, are there any? So it's opposed then with amendments. Are members in order with that?
Yes,
Just
Chair.
want to check if everyone was correct then in that regard.
Yes, Chair, in order.
Okay, I just want to make sure that I reflect everyone's views accurately. So then that is, and just for the record, I oppose with amendments. Because I also want to keep the word illegal in the act. Okay, let me just get to my bearings here. Clause
Chair, you
9.
must get your, Chair,
Yes.
maybe you have to get your bearings. Is it not support with amendment?
No, I think I may have made a mistake, because if I want to keep the word illegal, then I can't support this clause. Because what if they say to me they're coming back and they're not going to give me the word illegal in the thing? So then I think in this regard I need to make sure that I need to then oppose with amendments.
That's correct, Chair.
Is that correct?
Yeah.
Okay.
Miss Hassan Musa, I just want to check
Yep.
that my wording is correct. If they come back and they don't include the word illegal, then I don't want to support the clause. So then I must oppose with amendments. Okay. So sorry, that's a technical way of writing
Yes.
it. Okay. Perfect.
Yes.
Thank you so much. Then clause 9. Sorry, Mr. Daza.
Chair, can I just I think in terms of procedure from the NCOP side, there's not going to be another opportunity to deal with the bill clause by clause. The next vote is for the entire bill during the final mandate stage. So we will have to indicate the view of the province about the whole bill, not a clause.
True, but I think it's important that because it's called a negotiating mandate, and the purpose, even if other people don't want to do it, the purpose is to negotiate. So for me, I want the word illegal in the clause. So then I have to ask myself, okay, if the NCOP doesn't include that amendment, that they keep illegal in the clause, do I support the clause? And my answer is no. So then my answer is I oppose with amendments. Am I correct?
Chair, let me.
So basically, if I would oppose the clause if they don't give me what I want,
Yes.
then I'm opposing with amendments. Because maybe in the end, I might support if they give me the amendment.
Unfortunately, Chair, during the final mandate stage, the committee will have to decide on the overall bill. It might have to look at how many amendments we agreed to versus those that were not agreed to, then decide on the stance of the province for the final. But there's no negotiation, there's no clause by clause input.
Now, I understand that, but based on this clause, the current thing before me, I don't support the amendment. And if the amendment isn't given to me, I overall don't support the clause. So my view is then oppose with amendments. Okay. Clause 9.
Chair, if I can just add, I just want to hear from Mr. Daza what he said now.
So he said, remember when the final mandate comes to us?
No, I heard what he said, but I heard what he said. All that I want to know is, this is just what I understood now, what Mr. Daza said. There's a lot of clauses that we don't agree with. So the end, at the final mandate, we're just going to ask one question: to support or not support, and then we're going to say we're not support. We're not going to support it because of all the clauses we don't agree with, that we opposed. So that is what he's saying. Eh? So we're just going to ask one question, and as a province, we'll say we support or we don't support.
That is correct. So, for example, if the NCOP comes back and it gives us everything we want, we might change our mind on something. And if the NCOP comes back and it gives us nothing or partial of what we want, and we agree with some of the stuff, or sometimes you agree enough to want to support, sometimes you don't agree enough in order to support or object. But I think it's important that we put our true version of our views respective on the clauses, instead of simply relying on whether or not the NCOP will give us what we want. I'm hoping I'm making sense, Member Christians.
No, it's fine, Chair. Yeah, 100%.
Okay. Okay. Clause, where was I now? Clause 9. Members?
Chair,
Member Fry?
I support, subject to the amendment that reads, in cases of serious misconduct involving physical or sexual violence, the learner is suspended pending an investigation or being heard. In a situation like this, a time limit should be placed on the student's right to be heard, or an opportunity to provide reasons for why the suspension should not be implemented. For example, they must be heard within a week. To do this, we need to have two clauses in the Act that differentiate between types of serious misconduct.
Okay, so you want DBE to bring us amendments?
Yeah.
Okay. Let me just have a look. Member Christians?
Chair, yeah, I think there is just examples of serious misconduct. I'm just asking. I don't think there is a different. How do you understand serious misconduct? How do you determine the serious misconduct? I don't think it's in the definition. I don't think it's. I don't know. Just help me quickly. I just think what Member Fry said. Serious misconduct. There's instances, cases like stabbing and rape. That's serious.
So Member Fry suggested that DBE must include the differentiation between the different types of misconduct, including serious. I'm not sure if you want Member Fry to elaborate or if he needs to repeat. I'm not sure what the question is.
I'm just saying, no, I agree with him. I'm just saying, at the moment, it's also vague for me. Anything can be serious and anything can be, so misconduct is misconduct. How do you determine between serious and just misconduct? So I agree with him. I'm just thinking, how can we navigate that?
Okay, thank you so much. Let me just have a look here. I just want to check, Mr. Ndlebe, is DBE able to put in definitions and differentiation for the different types of misconduct for us, please? Is DBE amenable to it?
Yes, ma'am.
Okay, so
It's
DBE
something that is doable.
Okay, so amenable to including differentiation of different types of misconduct. Okay. Member Poole?
I'm in support of Member Fry, Chair.
Thank you so much. I'm happy to support Member Fry as well, especially since Mr. Ndlebe has indicated that DBE is amenable to including the differentiation of different misconduct, particularly including serious misconduct. Okay, and then Member Harris indicated she supports clauses without amendment. Okay, perfect. I'll just write here 4 times. Okay, now we're at clause 10. Just have a look here. Okay, clause 10 is amending section 10 of SASSA. Member Fry?
I support clause 10, Chair.
Thank you. Other members?
Me too, Chair.
Thank you, Member Poole. Member Christians?
I don't support clause 10, Chair.
Okay. Do you want to include a reason or an amendment?
No, I just think it can be struck. Although it's I would just say no, just remove it.
Okay, for the record, I support. Okay, and then member Harris also indicated support. Then clause 11.
Chair, I'm support, Chair.
Okay,
I support you.
okay,
Support, Chair.
okay, so everyone's in support. No amendments. Clause 12.
Chair, I support with the amendment that was recommended by the National Council for the Blind, that the amendment of Section 12 of the SASSA, the Schools Act, relating to the application of a school being designated as a public school with a specialized focus on talent, that specialized focus on talent be expanded to include a specialized disability for learners with special education needs. Thank you.
Okay, members online.
Support, Chair. Support that.
Support my fellow member.
Thank you so much. So there's support with amendments. I also support, I think the SA National Council for Blind really sent us some really good proposals in this regard, and it deserves being included in the bill. So I support also, so that is then clause 12, support with amendments. And so how does that work? The member Harris technically objects to the amendment but support the clause. So, but just hang on, I'm just get my wording now correct because it's now other way around. So the amendment, we support member Harris. Just for the record, I need to make sure that I got my technical wording correct now. Do you support the amendment that we put the clause from the National Council of Blind in? Member Harris?
Chairperson, as indicated earlier on, I support the bill as it stands with all of
Okay,
its
now,
clauses.
okay, so I just want to make sure. Okay, so I just want to make sure that I've got my technicalities correct now. Okay, so I've put the amendment.
No, you have it correctly captured
I have it
there,
correct.
Chair.
Okay. So
Yeah,
for the
yeah.
for the writing purposes of the procedural officer, I've now put the amendment. There was 4 support of the amendment and 1 oppose. Okay. Then because the amendment was adopted, I put the full clause with amendment, right? So now technically, member Harris, yours is opposed because you don't want the amendment that we've proposed. Am I correct?
Absolutely, I'm supporting the clause as it stands currently without the amendment.
Okay.
Yeah.
So, okay, so then for the record, I've put the amendment, 4 members voted for, 1 voted against. Then I put the full clause with the amendment, and the 4 members were for the clause with the new amendment, and member Harris is opposed to that because she supports the clause as it stands. Okay, I got it. Sorry,
Yes,
it's just
thank you.
the
Properly
legalese.
captured. Yes, properly captured, Chair.
Perfect. Okay. Now, clause 13. Let me just have a look here. Okay, members. Clause 13, that relates to, let me just have a look here. To the amendment of section 12A. Member Fry?
Chair, once again, the recommendation from the National Council for the Blind to amend Section 12A of the SASSA relating to instances where 2 or more schools are merged to include LSEN and specialist school mergers. I support with the amendment that I just tabled. Thank you, Chair.
Okay, so member Fry is requesting that we add the proposed clauses that the National Council of Blind have sent to us regarding this clause. Okay, members online, how do you feel about that?
Support with amendment, Chair.
Thank you. Member Christians?
That's in order, Chair. Thank you.
Okay, so that's ×4. So that will then in the record reflect similarly that 4 members then support the amendment. 1 does not, that's opposed. Then where this will read voting on the clause with the amendment, it will read 4 members for, with member Harris opposing because she wants the original clause to stand. Okay. Ek is op het, ek is op het. Clause 14. Member Fry?
I support this with a possible amendment. Far be it for me to act to speak on legal matters, but doesn't it say the clause already says in consultation? It doesn't need to also say that and after agreement. So and the clause should be an opt-in, not opt-out. So that's the changes, the possible amendments I have, but I do support the clause.
Okay, so you're supporting that it continues reading in consultation for legal purposes, and that, okay, and just commenting that the clause must allow people to opt into central procurement and not opt out. Okay, I'm with you. Members online?
I agree with
support,
that, Chair.
Chair.
Okay, I heard members Christian and Poole. So then that will be support with amendment. Okay, with a comment regarding that we want schools to be able to opt in and not have to opt out. Okay, so then that will read similar to the previous clauses regarding how the amendment is put. Okay, let me just write that down. Okay, clause 15. Let me just have a look here. So the amendment is asking that schools be opting in. Okay, okay, I'm with everyone. Then clause 15. Member Fry?
Chair, I support with the following amendment that we create greater clarity regarding the powers of the HOD to withdraw functions of SGBs and indicates the process that needs to be followed when these functions are withdrawn. I think that this is necessary to ensure functional SGBs, but it must this will expand on this power in greater detail. Thank you, Chair. So yeah, so my amendment is that we create greater clarity regarding the powers of the HOD to withdraw functions of SGBs, and indicate the processes that need to be followed when functions are withdrawn.
Okay, so you want DBE to make those changes. Okay, members online?
Support, Chair.
Okay, member
Yeah,
Christians?
Chair, I don't know. I'll leave it like it. I'll support it. I'll leave it like it. Okay, Chair, thank you.
You don't have to. I don't want to force you into anything. Please, you must say what you want to say.
Okay, we can continue. We can continue. Fine.
Okay, no problem. Okay. So that will then read similar regarding the amendment and the support the way we did with the other amendments. Okay. Then clause 16. Let me have a look. Clause 16 relates to, thank you, Member Poole, relates to SASA 23. So Member Poole has indicated support. Other members?
So, Chair,
yes,
support with amendments is WCED request amendment definition of community be inserted or alternatively the term be deleted. Provisions to be drafted to apply to any person with the relevant expertise. Thank you, Chair.
Okay, so you want 3. You want community must be clarified if community is not clarified, then the term must be deleted, and that there must be provisions to say to apply, to be drafted to apply to any person with the relevant expertise. We want to know what that means.
Yes.
Okay, ek is met jou. Member Fry, you had your hand up.
No, I concur, Chair.
Thank you. Member Christians?
Fine with that, Chair.
Okay. And just for the record, I'm happy with Member Paul's suggestion. And just for the record, Member Harris's vote will then read similar regarding the amendments and the clause as she's previously indicated. Clause 17. Member Fry?
Chair, I oppose this clause because the transfer of the power as indicated would lead to greater centralization of power. And this could be an unjustified intrusion into the provincial sphere, and therefore this clause should be deleted. Thank you, Chair.
Thank you. So, okay. Thank you so much. Other members?
Agree, Chair.
Concur with Member Fry.
Okay, so everyone is agreeing to then oppose, except Member Harris's vote will read support of the vote. Okay, so that's oppose times 4. Mine is also oppose. Then Harris support. Okay. But let me just check. You asked with him. No, it was just oppose. Okay, it's just oppose. Okay, clause 18. Member Fry?
Chair, support the clause.
Thank you. Other members?
Support the clause, Chair.
Thank you so much.
Support.
Okay, thank you. And just for the record, I support it as well. Okay. Then clause 19. Member Fry?
Chair, the 14-day appeal against the HOD's decision to dissolve an SGB should be extended. It's not realistic for a 14-day appeal. I would say at least a 45-day appeal or even a 60-day appeal. But I would say that 14-day appeal procedure is just too short. Thank you, Chair.
Okay, I just want to check quickly. Do you want to put a timeline in, or do you want to ask for a longer period?
Let me ask for a. I think we should ask for a longer period, Chair.
Okay, members online?
Support Member Fry, Chair.
Okay, Member Christians?
Chair, I wonder if we ask. I don't know if we must put in a 40 or it sounds extremely long. I think it's long. If and a person cannot now put in vague stuff. I'm just thinking 14 days or a reasonable time. I don't know a reasonable time. What is a reasonable time?
Can I just check? Can I just check with the DBE and WCD if they are online, what they would be amenable to in terms of a longer period? Is it 21 days? Is it Mr. Ndlebe?
Thank you very much, Chairperson. This takes us back to the comments that we received during the National Assembly. And this has been highly sponsored, especially by SGB associations, including organizations such as SAOU, where they were saying the number 14, it's a consistent number in the department in most of the policies. So if we start playing with dates and they differ, it then confuses the sector. And 14, remember, when people are appealing and there is an issue, there is a need to immediately resolve that issue instead of letting it drag for long. schools only have 200 days in a year. So if you take 45 days where nothing is happening, people are still dealing with the appeal, it means the school year will be gone. So there was a strong emphasis on sticking to 14, Chairperson, and that's how it was. It was in 14 before, but it came 14 because of those motivation that everything in the department, every appeal in the department, it's 14. So let's not have different dates for appeals. Thanks, Chairperson.
Okay, I'm not sure about the National Assembly and other provinces, but there were multiple people in our submissions that wanted a longer period. So our question now is, how do we find the balance? For example, if we take 14, if we went to 21, would that be amenable?
Chairperson, from our side, we'll stick to 14 if you don't want to fight with our stakeholders that we're feeling very strongly about the 14, those that work with school governing bodies. I'm talking here of the FEDSAS, the NSGB, the all SGB associations that we're saying, give us shorter timelines so that issues can be resolved immediately. Thanks, Chair.
Okay, thank you. Perhaps the stakeholders at national and the stakeholders by us were different in terms of the submissions. Members, do you want to put a specific timeline in, or do you want to simply advocate for a longer time period? I'm in your hands here, members. Member Fry?
I'm a bit torn, because I don't think, a reasonable time. What is a reasonable time? Is how long is a piece of string? But I do think 14 days is too short. Given what Member Christians has said, that I would say 30 business days would be 30 school days. So Monday to Friday, 6 weeks would be a good So that's my recommendation, Chair.
Okay, I'm a little bit more inclined to a little bit less time. Colleagues, would you like me to park clause 19 and come back to it? And we can always do it after a mini 5-minute break.
Chair, I don't know now, because what DBE has said now is stakeholders in that asking for the 14 days so that it be dealt with. Why don't we just, I don't know. I think 21 days, you suggested 21 days. It's the middle road to go. So I would go with 21 days. Thank you, Chair.
Thanks. I'm amenable to negotiating on this point. I'm not specific in the amount of days I want. If the stakeholders want 14, I'm happy. But from the submissions that we have received as a province, stakeholders have asked us for longer time. So perhaps the stakeholders in the 5,445 submissions that sent to us is maybe not the same stakeholders that emailed to National. I don't know. But I'm trying my best to find a balance here for us. So what I can do is I can park clause 19 and come back to it after a mini break. I just want to check. It is 5 to 5. Members, would you prefer at 5 o'clock that we continue on Monday morning? That we conclude with clause 20 then? Or what would we just take? Okay, give me a second. Let me just take procedural advice quickly. Thank you. colleagues? Okay, colleagues, because it is 5 o'clock and obviously we've already gone over time and I don't want to infringe upon people's private time after 5 o'clock on a Friday, my suggestion is this. Can we continue with the clause by clause Monday morning, 8 to 10 o'clock? Reason being is we've already been able to do 20 clauses within an hour and a half now this afternoon because our submission tabling is done. Then my suspicion is we'll be able to conclude the rest of that then within the 2 hours on Monday morning. But I just want to first check with members because you may already have something in your diary.
Chair, thank you. If I
Yes,
can just
Chair,
add.
Chair, I have a problem because I have another commitment at 9 at our offices. So yeah.
I could always propose 7 to 9, but then members must be prepared to come in early.
Chair, 7 to 9 will work
That's
for me
okay.
because I've got a 10 o'clock
That's
meeting.
okay.
So 7 to 9 will work for me.
Okay, and
That's okay.
are members okay with us making that virtual? Then we don't have to
Yes.
book a committee room.
Yes.
Yes, Chair.
Okay, then because we were debating clause 19 now anyway, what we'll do is we were going to park it anyway, so let's stop there. We pause at clause 19. We continue with clause 19 Monday morning at 7 o'clock. And I will ask the procedural officer to urgently just ask programming to schedule that for us for 7 to 9 o'clock, virtual for the continuation. And the motivation being that it is legislation before Parliament, that it is important, it is urgent, because our negotiating mandate is due on the 17th. Thank you so much, members. Members, I just really want to say thank you. I know legislation can be long and tedious, but I always appreciate your abilities to stick with me here and pay attention and remain present because of the impact of this very, very important bill. To the DBE and WCD and legal and procedural officers, everyone, just thank you so much for being with us. We are thus then going to continue at 7 o'clock on Monday morning. We hope that you will be present because we may have some extra questions for you on particular matters. But at least with some matters that may need some negotiation, at least the members will have a bit of an extra weekend should they need to do so. But with that, for now, the clause by clause is suspended, but the meeting is adjourned. Thank you and goodbye.
Thank you, Chair. Thank you, everybody.
Goodbye, everybody.